Number one. One and two. That's my affiliate.
It's not the advantage. Yes.
So my basic stand concept which I have taken in the affidavit is that there was an error. In fact, in after 1997 also that initial eligibility certificate was given. That was also an error. So let's say in that regard, let's say, the stand I have taken the page 7 here also. I'll just give read out some portions so that like let's say we get the sequence of the events how it has happened. Page 7 and paragraph G here also. Is it okay?
Yes.
It is to be mentioned that in the year 2003, the state government of Assam enacted Assam Railway Tax Act 2003, and in exercise of power conferred under subsection 4 of section 109 and the Associate Act 2003, the governor of Assam was pleased to create Assam Industries Tax Limited Scheme 2005, substituting the existing Assam Industries Sales Tax Act 1997. So here, I have stated that like the definition of manufacture that 30 that has been specially brought. Then also the next paragraph, page 8. Then the limits of tax remission scheme that I have forgotten also. Lordship has already seen it. I will not read out the whole thing, but it says about the manufacturers. The limits of tax remission of eligible units, the eligible unit registered and so manufacturers including the site. So manufacturer is passed there. It is therefore stated that the Assam Industries Sales Tax Concession Scheme 1997 as well as Scheme 2005 from the very beginning of the coming into the force were very clear that to gain sales tax exemption.
Mr. Kolita,
Lots.
why are you making this argument?
No, Lordship, why?
You have issued an eligibility certificate.
Right.
The entitlement certificate is to be issued by them.
By them.
The remission scheme is made by them.
Right.
It is only in consonance to your industrial policy. That's all.
Right.
Whatever you have done is you have given him an eligibility at that point of
I
time.
have given him, Lordship,
But you have never cancelled that eligibility at any point of time.
we have not cancelled it.
Now, relying upon the manufacture of remission and all, this is for him to say, why are you arguing this?
So, Lordship, because ultimately, like it will boil down to one thing that the eligibility certificate. How eligibility certificate was given, and our stand is also that
Eligible at the time when the eligibility certificate was given, the manufacturer definition which was there
yeah, it was for production. Okay, it was finished product.
would have included what they have done at that point of time.
So that's what Lordship was very correct in saying. So what Lordship, I was pointing out Lordship over 1997 fact also and the scheme also. There also the finished product thing is the definition of finished product. Then Lordship that
No, whatever may be a finished product or whatever may be, but the question of the definition of manufacture as it stood in the 1993 Act categorically mentioned what would be, and the definition of as per the 1993 Act as well as the 2005 Act is different. Now you are therefore saying that now the manufacture which is being done could not, after the scheme which is coming has to be read along with the manufacture which has happened, which is the prevailing law. So the manufacturer has to be dependent on the prevailing law.
So Lordship, that is correct, but like, here.
But that prevailing law has been brought in by the tax department. You have not changed anything. You remain as it is, the static from there till the eligibility certificate has spent its force.
No,
Because you never cancelled it.
no, we haven't cancelled it because we did not get the opportunity to cancel it.
Why?
Because they have proposed that whenever we have done like, I mean, tax department had issued an notice.
Forget about the tax department.
Like,
No.
then
when
they
you
approached the
say-
court also.
No, Mr. Kolkar, the thing is different. When these departments are appearing differently, then you cannot say that I am up for the tax department, I will take care of what the sales tax department is
Now,
now.
that is why Lordship, I mean, like sequence of events is very important, Lordship, because I think
The
2008.
sequence of events, what did you do
the
for
Lordship,
cancellation of the
they
eligibility
immediately
certificate?
immediately have one of the High Court Lordship,
Who?
the notice package case is there,
That, they came in 2018
2008 Lordship.
or 2008. We are concerned prior to that.
Yeah, Lordship, yes, when we.
But notice packaging is a case which came into existence pursuant to the 2005.
Correct, Lordship.
But what stopped you
So that
from
is.
even issuing a notice? You didn't do anything.
My this thing is that Lordship, when this entitlement thing came, and for entitlement certificate they came, if applied it, then this error has come to the fore. So then immediately Lordship, we wanted.
Did you communicate to them not to issue this entitlement certificate at any point of time?
No, then only they have approached. the court and-
You have just woken up one fine day when the sales tax department didn't give them the remission.
No, Lordship,
That is when you woke up.
ultimately,
What
Lordship,
steps did you take earlier, the industries department?
ultimately.
You allowed the entire, that particular eligibility certificate to spend its force.
No, ultimately, Lordship, it's a two department, SLC is the same, two department is there. So ultimately, we have to take their views also regarding all these aspects. I mean, if we need to give an eligibility also, they are also part of the SLC.
So why didn't you do anything at any point of time?
So.
You should have told them immediately. Then look here, now the manufacturer definition is there. So our eligibility certificate which has given to them should be cancelled. Why didn't you inform me?
That is admitted, Lordship, that there was an error committed by us.
So?
That is admitted. Now, Lordship, like, when the error has come to the.
What is the error?
The error that like we have given them an eligibility certificate.
No, your eligibility certificate which you have given,
Lordship,
was it bad at the time when it was given?
that's what I'm saying, Lordship, that was also an error.
Why?
Because Lordship, like in the finished product and like Deepak Potter's case, if the Lordship takes it into account. And Deepak Potter's case is also similar. I mean, the mustard oil has been stated that like it is not a finished product.
Hmm.
So now in the water purification system also in this process also, it is only the water, the raw water that is purified and bottled. It's the same process they go through. So like if the Lordship takes it back on a Deepak Potter's case, so it also comes to the conclusion that it is also a process where.
So are you agreeable
Lordship,
if we set aside this? Would not, means, are you agreeable? We don't interfere, but as regards the earlier amounts which have been taken by them, that should be taken from the industries department and paid to the sales tax. Are you agreeable to that? Because, no, that has to be, because once you have made a mistake, you should have corrected it. Why did you wake up after 2008? When, and that too at the behest of the Commissioner of Taxes who had issued that notification?
Taxes are part of the government.
What part of the government?
It's the state government, Lordship, ultimately. It's a SLC. SLC is formed by the state government. Policy is by the state government of Assam. Lordship.
Then why didn't you issue the, no, then why didn't you issue the, now have you seen Suprabhat Steel? Have you seen the judgment of Suprabhat Steel? You have not seen? Yes, Mr. Sharaf, give him the citation. 1998,
I mean, the government.
one
has to-
SEC page 1 or 16. Give it to him.
But is it Lordship, the government has to speak into one voice? I mean,
Absolutely not that. Once a certificate has been issued or the cabinet has taken a decision in this regard, the department is out there cannot say that, no, we are not going to abide by that. Now the decision of issuing the eligibility certificate was yours.
So now Lordship will take a decision on that whether when the error has come out, now whether error can be rectified.
Now, can you rectify it at a later stage when they have on the basis? Now, kindly see one thing. you, on the basis of that eligibility certificate, they get the eligibility if they come up with a new industry or make modernization, diversification and all, making it by another, increasing the capacity by another 25%. Then for that 25%, you are going to give them the benefits. That is the eligibility criteria. Now, if that is the eligibility criteria out there, then in that regard, the manufacturer which was there at that point of time, and on the basis of that, you have issued the eligibility certificate saying that for these 3 items, he is entitled to. On the basis of manufacture or not, it is not known, but you have given the certificate to the. Then one fine morning, you wake up and say that no. Let me fight for, let this industries department fight for the finance and taxation department. Are the finance and taxation department incapable of doing it? Let Mr. B. Chaudhary make his arguments on these aspects. But why should I hear you being the industries department? Unless you say that the industries department and the finance and taxation department is one and same, and you are going to make the argument for them, and the finance and taxation department shall not make any argument. Say that.
I will not.
But you can't, I won't hear for, if you are saying that you are doing it for both, then it is okay.
No.
But you are not.
He'll argue his part, then
Why will he argue for his part? Why should I hear 2 counsels for the same thing?
Then
If you are speaking, saying that we are speaking in one voice.
Lordship, then I'll do one thing, Lordship. Only thing is that like couple of case laws, Lordship, I have got it. So I'll just replace those. The effects I have already.
What is the case laws?
Case laws regarding promissory estoppel and as well as whether mandamus can be issued when a error has come up or like some illegality has happened and it has come up. Those 2 points I'll place this case law and then Lordship, Lordship.
Promissory estoppel, which judgment?
Promissory estoppel, Lordship, this is the Dr. Ashwin Kumar Maheshwari.
What does it say?
Para 8, 10, 11, 19, 20, 21, and 22.
What does it say? What was the case involved?
It's regarding promissory estoppel. Doctrine of promissory estoppel. It says about government policies and when the doctrine of promissory estoppel can be applicable and when not. I'll just read out what's in that relevant paragraph. Paragraph 8 here. Should I read it?
Your case is under paragraph 20.
Yes. Paragraph 20 is there, 21, what's it?
Paragraph 20 is your thing.
Yes, sir.
The basic principle is that the plea of estoppel cannot be raised to defeat the provisions of a statute.
So all these paragraphs also narrates that the same thing only, that is the principle. The statute says that manufacturing is there, so manufacturing is not there, then promissory estoppel, I mean now, it cannot be.
But it was there at that point of time.
97 part proceed.
You see, the fact-finding inquiry was done by you or them. Both of you have come to an opinion that yes, it is amounts to a manufacture. Now, can you later on say, oh, we made a mistake, we have now changed the opinion? Who thinks that it was a mistake? Tell me, who thinks now that it is a mistake?
When this Kerala case came out,
The Kerala case was much prior to that. It was in the year 2003.
2003.
So what stopped you? Because they got that eligibility certificate in the year 2003-04. Then, in spite of the Kerala case being there, why have we done that?
That is an admitted part that we have.
No, therefore, who changed the opinion?
So this is not change of opinion because of the statute and like because of the
No, but the statute was all along
the
there.
statute was there, but like there was a confusion in the interpretation.
When?
Normally it was
So So as that there was a confusion.
No, 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 that I have stated. in
When did the
my-
confusion, tell me, when did the confusion start?
No, no, when this.
No, you tell me, when did the
When
confusion start?
confusion started, so what has happened, the clarity came. When-
Clarity came in 2008.
That's
Then-
admitted part, that's admitted part. Now that the clarity came, that because of the few judgments of the honorable court.
So there was a confusion.
I mean, otherwise, they wouldn't have issued the certificate already. Because manufacturer was already there.
So it was a change of opinion, which later on have happened.
It was not exactly, I will not say not a change of opinion, because of the clarity came, and the laws laid down by this honorable courts. That we have got to know that, okay, that manufacturer is already there, and this process, bottling process.
The law was laid down by this, the law was not laid down by this court. It was the commissioner of Texas who woke up one fine day and said, then look here, these packaged waters would not come within the ambit of manufacture.
Because Kerala High Court said so.
But Kerala High Court said in 2003, then also nobody did it. And did the industries department at any point of time do it?
The notice of the department.
Why didn't you put them into the negative list?
Now it has come in the notice, what should be.
But
Now
Mr.
it has
Kalta,
come
why
to-
haven't you put him in the negative list? There are many other aspects.
Negative,
That's
like negative list is not exhaustive, or negative list is not exhaustive.
understood. But if you could have very well put by way of an amendment, put it by way of an amendment that this is comes within the negative list. You never did. The industries department all along has been silent, except fighting out this litigation.
The lordship, what has happened in 2008 when this issue has come up, then notice the casing and they have this organization, and this petitioner is also part of that notice. They have sought for a clarification.
After hearing so much, are you going to go into those technical pleas that are waiver
No,
and
no, no,
estoppel and all
I'm
these
not- I'm
things?
not saying that.
Kindly don't make those
What the
arguments.
department has given a clarification, and when the department has given a clarification, immediately they.
So
approach
the
court.
department's clarification, if it is so, it maybe has to be applied prospectively.
That lordship will decide.
No,
That lordship.
no, is it your case that it has to be applied retrospectively?
So what I was arguing is that lordship Deepak Poddar's case and 1997.
Deepak Poddar's case is on the question of raw master law.
It is a bottling plant lordship, the same.
But you have never taken any action on the basis thereof. The action was taken only by the tax department. That is why I'm saying. Who are you?
So later.
You have only issued the eligibility certificate. Now take your seat. Yes, Mr. Chaudhary.
The lordship, the other two cases. also.
Yes, what else?
I'll address. Here are 10 laws, 9 and 10.
Sir, pull it down. Why are you into this
That is also
1990?
technical for the lordship. So the matters can be.
The law is there, new law. Kindly show me the new law. Have you seen the unicorn industries? Have you read the Hindu Hirocop or what is that judgment?
That I have.
Isn't that the same thing which has been mentioned out there? Then why you are relying on the same judgments?
No, one is whether mandamus can be issued or not, and one is.
That is the same aspect which has been taken in unicorn. Then why you are troubling this court with unnecessary? That I have seen it.
I just placed,
I only placed it before that.
so I have given the paragraphs also, lordship.
Where?
But that's a long copy maybe, no, that's correct. So these are three cases, lordship may consider.
Industries
Then lordship may-
department.
Prospectively, lordship may not allow it, because of this case law as well as, I mean, the schedule and the definition is there. But as far as the other part, lordship may, yes.
Hey, Hindu Hirocop to good.
I've given the paragraph.
I don't use this Supreme to Good judgment. Bueno, la elección de fútbol. Está online. Even more judgment, more law judgment. I've taken out all CLR judgment. Where are those? These are all different books. কাগজ কিন্তু ঠিক রাখিব লাগে না আপনি ওই দিন ঠিক কিন্তু পেপার মই আকৌ ওলাম নি এইবোৰ এটাও নাই দেখোন where are you? And what specifically I have asked you people to keep it properly. I've asked you people to keep it properly. What is the problem in keeping it properly? No, not these agents. Not necessary. Judgment rule রাখিম তথাপি আপোনালোকে দিব নোৱাৰে
There's 23 one assistant.
কিন্তু judgment নাই these are not it. Let's sit down out here and find out these judgments now. Yeah? No, I have asked you to keep it properly. Why didn't you keep it properly? I have asked you to keep it properly. Yes, what else?
History of it.
Money je ulaila. You people are useless. Keep it
So
out.
also in my humble submission that error has been committed by the department.
Mr. Kulda, I am not satisfied with your argument.
With the eligibility
No.
certificate.
You are
So
nobody
now
to
that-
say all this.
Now error has.
First
come
of
up.
all, without seeing this particular 1998 one SSC page 6, you cannot make this argument. Because you are an industry department, you have all along sitting idle out there, you did not do it. This court is going to say, yeah, may not interfere with them, may not interfere, but the industries department has to pay to the sales tax department the amount which you have given for the earlier period. Because your error, you have done it wonder, and that shall be calculated from the salary of the commissioner of that. That is the amount which you have to pay. Because you have done that. You cannot, no, because you see, because of the opinion of your officers, a person has got exemption. Now, this court is not going to touch on that, those exemptions which you have already got. But as regards that, you knew it. And there is you cannot just escape by saying it's an error. It's a serious loss which has brought to the public exchequer. And can you just come out one fine day and say that, no, this is the state of affairs. We have made a mistake. So kindly condone it, but now don't give it to Endeavor any further. It is a public money. Public money, you can spend it, but the moment you want, another person comes in and says out here, no. Was that the person who issued the eligibility certificate? Was that the same person who had the opinion at a later point of time that there was an error? Then wouldn't that amount to a change of opinion?
It's not kind of a case error. It's an error that has been committed that has been agreed by the department, both the departments.
Both the department has not done it till now. I am yet to hear But I'm asking you, is it the same person who had issued the say eligibility certificate and later on have now said that the change in error? Yes, Bhagavad Gita.
It may not be the same person.
Hmm?
It may not be the same person.
So if it is not, wouldn't that come within the ambit of a change of opinion, and the Taparia judgment would apply by the division bench?
You know what I'll submit is that also there's no change of opinion.
Absolutely, the change of opinion.
So, yeah,
Very good.
it's not on the same statute or the same law that the opinion has changed. The opinion has changed because there was an interpretation came on later on.
So now you therefore you admit, as the law has changed, so the opinion, it is not the change of the opinion, but it is because of the change of the law. Are you saying that?
Now, from 97 to 2005, that's obviously also the manufacturer definition has been specifically brought in. That is a change. But as far as
No, are you saying therefore that there was no error?
no, I'm saying it's an error.
If it is an error, then it is a change of opinion.
Because of the error,
The moment you say it to be an error, Mr. Kolida, it amounts to a change of opinion. Unless you say that, look here,
no, lordship, now
no,
we-
Mr. Kolida,
Yes.
unless you submit that, look here, the law which was then there may have stated this is the manufacturer out there. But once the law had changed and the remission scheme, as well as the other aspects of the matter pertaining to even you, if you read section 109(4), will also mention that that remission scheme has to be in terms with the Act of 2005. And as such, now they would do not fall within the ambit of
The
manufacturer.
scheme.
So with the change of law, the continuation of the eligibility may be an error. But the issuance of the eligibility certificate was never an error.
The issuance was.
Because the moment you say that there is an error,
No,
it is the amount.
lordship, eligibility was issued in 2004. The scheme came in 2005.
Whatever mean, 1 year he may be entitled. Therefore, it was issued at that point of time in 2004.
2004.
If you say it to be an error, it would amount to change of the opinion.
Lordship, can you consider that eligibility certificate was given in 2004?
Have you mentioned it in your affidavit that it is an error?
It's an inadvertent error, we can consider. So we stated that also in 2004, this eligibility certificate was given. And 2005 it came. We did not take any action about this because we were, genuinely we thought that Rotary plan may come under the manufacturer. Then later when this issue came up in Kerala High Court things had come up. Then we.
Mr. Koilda, don't spoil your case any further with your arguments. Yes. Mr. Chaudhary, Mr. Kane Chaudhary's argument was, yes, 230 had been amended. Has been brought in, by which the definition of manufacture which was there prior to the VAT Act coming into force have changed. But as the petitioner was getting benefit under the old Act, and by virtue of section 109(4), an exception has been created for being a manufacturer in terms with the Act of 1993 and not in terms with the Act of 2005. That's his submission. What is your reply?
of all, section 109, subsection 4, that exception that has been created, it came into effect from 2007. It was not at the initial stage, it was subsequently amendment was done. That at that point, the exception came into effect. Yes.
You're referring to where?
Section 109, subsection 4.
Yes. Was there any amendment?
Lordship, yes, in the lordship, in this book, it is written.
Ah, but here it is not so.
Lordship, it came in subsection 4, the proviso was inserted in effect from 30th March 2007.
What was the proviso? There's a proviso.
This proviso that exception provided that further that lordship.
No, that proviso is not here. No. Further, that when exemption is granted in the form of remission, the eligible will be entitled to retain the part or whole of tax collected by way of subsidy from the government, subject to the maximum permissible limit. How is it relevant? This is only the scheme of remission.
Yeah, with regard to the
Because what was found out, because as per the act or as per the industrial policy, they were entitled to exemption, meaning thereby they need not pay for purchase of the goods as well as also need not pay for sale of the goods. That was it. Now, what has happened? You brought in the remission scheme. Remission postulates that they will pay and 1% you will retain and 99% you will refund. That is the remission. Now, problem arose around as to there might be a case out there where on one hand you are saving the sales tax concession scheme by 1094, but you have not mentioned about the remission, and therefore the proviso is brought. But this proviso has otherwise no other effect other than what has been mentioned in 1094.
I'm trying to say came into effect on
No, 1094 was all along there.
Yeah,
It is only the proviso. The proviso is only for the purpose of remission to make it proper. Then at the later stage, people may not challenge, because then you can very well say that by way of an amendment or by way of a statute, we have already brought in, and as such the question of promissory estoppel does not arise.
Lordship, here, since they were having the exemption certificate, the certificate respect to the 1997 scheme, when this 2005 scheme came into effect, they were required to reaccount so that they can continue that 1997 scheme training. And while we are applying, lordship, they will have to satisfy all those sites satisfying the industrial policy conditions. Lordship, they have to satisfy the condition laid down in the VAT. And
Or you may say that they have to satisfy the conditions of the scheme.
yes, 2005.
Because when a person duly applies, like it has to be given a literal interpretation. A person who applies out there, a person who applies for getting an exemption has to prove that he comes within the ambit of eligibility.
And while the application came in, they submitted, also taking into account the definition given in the act, with regard to manufacture, it appears that they were not manufacturing a new product. And in that, meanwhile, that notice that they applied before the commissioner of health to clarify with regard to that whether it will amount to manufacture or not. And accordingly, lordship, Commissioner of State Tax clarified that it doesn't amount to a need for it. And so the Commissioner of State Tax get that clarification, then the authority under the tax department, they have to deny that benefit and make necessary assessment. And that was the assessment that had been to challenge. It was with regard to 2005-6 lawsuit. And the scheme came into effect from 2005. So, and subsequently, Northeast package came into existence, lawsuit. So, the authorities under that, while we are trying, the tax authority losses under the existing law, they acted.
And another aspect, the benefit as per the earlier act or earlier scheme, the tax concession scheme, the payment was exempted from payment of tax on purchase of raw materials as well as on sale of finished goods. That was the exemption under the sales tax concessions. Now, 1993 Act is completely silent on the concept of remission. So now the scheme brings in the concept of remission, and therefore you have the provision. Now, if the scheme brings in the concept of remission, they ought to have either challenge the scheme. Have you challenged the scheme? If they have not, then their remission can only be given to them on the basis of this act only of 2005. Can it be given under the 93 Act? No. Or under the sales tax concession scheme? No. So the remission has to be only as per the Act of 2005. And if it is so, whether 1094, even without the proviso or with the proviso, would be an exception to Section 230. Because that boils down to that only, nothing more than. Because 1094 states about the act. Means the VAT Act. Let us assume that 1094 is an exception to 230. Let us assume, let's take the best case of the petition. Would it then come then also would they be entitled to the benefit of remission under the scheme if they don't manufacture as per the act? Because there the manufacturer has been given. Let's see the remission scheme again. Yes. Kindly come to section clause 3 of the remission scheme. When eligible unit will be a person who is a new unit or 25%. Registered under the Assam Value Added Tax Act 2003. Manufactures any goods in Assam other than those declared above as not eligible, 99% of the tax payable by such unit according to its return in respect of sale of such goods manufactured in such unit shall be eligible for remission or continue to be eligible for remission until the amount of such tax payable exceeds the unavailed quantum of monetary ceiling or the extended unexpired period of eligibility which is earlier. The unexpired period of eligibility shall be extended by the following formula. Kindly come to 10. When eligible unit has made an application for eligibility certificate in accordance with scheme, and such superior has been pending for disposal, or an eligible which makes an application for under the scheme and such superior remains pending for amount of tax due during this period under the act shall be remitted in accordance with the provisions of the subject of this scheme, subject to the production of a certificate from the competent to issue such year that the application of AI on the basis of the certificate remission of tax can be granted for a period of 6 months. The eligibility will be 6 months. I count to 11. The eligibility certificate is granted to an entire industry which fulfills all the eligibility conditions in terms with the Assam Industry Sales Tax Concession Scheme 1997. And for the purpose of getting the certificate of entitlement to enable the industrial unit to enjoy the benefit of tax remission in terms with this scheme. Violation of any conditions of the eligibility or information on these ground conditions being found false at any time after the issue of the eligibility certificate or obtaining such certificate by showing fraud or failure on the part of the holder of the demand to comply with any conditions laid down in the certificate of entitlement or to furnish any information required by his prescribed with regard to the implementation of this shall entail the termination of both the eligibility and certificate. Notwithstanding the substitution, all proceedings relating to the issuance of eligibility and the certificate and any other proceedings under that said scheme in respect of any period before the commencement of that may be taken or continued as if this scheme has not been passed. What do you say about 12?
Well, Lordship, in respect of those applications that that may have been applied for 2003. And no decision.
All proceedings, not applications, all proceedings relating to the issuance of IMAN and certificate of authorization and any other proceedings under the said scheme in respect of any period before the commencement of this act may be taken. So that is only saved. And what do you say about the certificate of entitlement not being issued? Without the certificate of entitlement, can he get the benefit of the scheme? It may be a different thing. You may be illegal. You may be illegally holding, but that is not the subject matter before the court. They have not asked for. Have you asked for? They have not asked for the certificate of entitlement to be issued. Now, without the certificate of entitlement, can they be entitled to the tax remission?
My humble submission. They will not be entitled because only on getting the, because as per the scheme, only on getting the certificate of entitlement, the earlier benefit that they were getting in this, the case of the British project, that will happen. If it is not given on and it appears that responded that they do not fall within the ambit of manufacture as defined in the act. Right. Because as per the scheme laws, as per the policy, industrial policy, and the scheme of 95, there has to be a manufacturer of the finished product.
As per the 93, as per section 94 also. Let us see the AGST Act for a second. As per section 222, as it stood, it does not require that a new product has come into existence. But as per 230, a new product has to come into existence. Because the word more particularly used is produced. And in Deepak Poddar, the division bench held Deepak Poddar, I think paragraph 18. The word production has not been defined in the Assam Act. The court will therefore have to understand the meaning of the said word by reference to its everyday common use where it speaks. There can be no dispute that the production denotes bringing something into life or existence by human effort. Such human effort naturally has to be on something already existing, though it is not impossible to visualize production of goods also from non-existent goods, that is mining of minerals. If something already exists, what would come to life or existence, therefore, logically has to be something different. That is something, as been said, the word production has a wider meaning than the word manufacture. While every manufacture can be characterized as production, every production need not amount to manufacture. Or produce, when used in just with the word manufacture, takes into bringing into existence new goods by a process which may or may not amount to manufacture. It also takes in all byproducts, intermediate products, and residue which emerges in the course of the year. Filtration of raw into mustard oil undertaken by the therefore cannot be understood to amount to production in view of the above. So this judgment came in 2010 also. So what was the status out here as regards the eligibility? Accordingly, the petitioner being eligible, the directors of industries have granted eligibility certificate to the petitioner on demand, certifying the petitioner's unit to be eligible for sales tax exemption on the finished products manufactured in the unit as well as raw materials, which was held on demand. It was specifically mentioned the raw materials on which the petitioner would be entitled to are mustard salt, so and so and. However, the district level will be meeting to the decision that the filtration of demand and thereafter packing the figure in which was undertaken by the committee, therefore, But in Deepak Poddar, if you read paragraph 5, after the district level committee had taken some decision, the industries department, unlike in the instant case, woke up and amended them, which was, however, not done.
This is that is the only difference. But in that case, amendment has been done. In this case, amendment of which.
That is why, na? That amount which he has got the benefit, you take it from from those persons. Salary of those, including Mr. A. Kolita. Well, but your case primarily would be without a certificate of entitlement, he would not. And as such, as there is no certificate of entitlement, where is the question of he getting any benefit of remission? And it is not the case of the petitioner that he had asked for the certificate, not being given, he has approached this court.
It challenges the assessment order.
Huh?
It challenges the assessment order.
They only challenge the assessment order here. And this assessment order, no, this is challenge is the revisional order.
Yes, it went on.
The revision. No. Assessment order was made in their favor, in your favor,
Yes, boss.
and then the appellate authority decided in his favor, and then he
He went on,
revision. And what are the other two matters?
Item number 1 is regarding assessment year 2005-6. Item number 2 is regarding assessment year 6-7 to 10-11.
10-11, how do you get it? From 2004 onwards?
Mode of calculation of the labor contract strike or
No, from 2004. From 2004, 7 years.
6-7. And even from 2002 also, 2009, in the manner of calculation of the next strike period, it gives some extent. Lordship has just come to manner of calculating the next strike period in the scheme 2005. It gives some extension to the next.
But you got from 2004.
First, 2002.
2002 also you got. And 2004. They are not, in their assessment, no problems.
No, problem was there in the original assessment. But the original of the
For assessment year 2002 and 2004, there was no problem.
report.
The problem arose after 2005. And why have you filed one writ petition for all the assessment years?
As a common order. I think different petitions for the other constitutions.
Huh?
Filing different petitions for the, against the common order. The other cause problems to the
Cause problem for who?
application. Because 5 years have been going to be common order.
So, are you saying that each had a different assessment? Same assessment? One's assessment order for all these years?
Corrections for assessment like past, assessment was not done.
Just for example, I dismiss your petition both. You file one appeal. Can you file one appeal? No. How can you file one petition for assessment order? Similar matter goes, whatever you have done, it is okay. But no, as it is not before this court.
Court tell heavily about me lordship. 5 years, 5 petitions against the common order.
But had the court looked into the judgment of the Supreme Court in BSNL, wherein it categorically says that each assessment order is a separate proceedings, and as such, an order passed in each assessment year may not apply as res judicata for the other. Isn't that the judgment of Justice Rumapal? Then if that be so, how can you file in one with petition?
The basic proposition which has been added in one assessment, that might be applicable for further assessment here, but the quantities and the.
So therefore it should be, each assessment year has to be different, separately done. Why have you done one?
Should higher assessment here, common order has to be passed as a.
And how many appeals did you file? They filed? You filed against the original assessment?
I have five appeals.
Then,
It was disposed
because
of-
that is the manner how you do it.
Common order that appeal.
Obviously, today I will dispose of, are you saying, do you expect this court to dispose of this petition separately and that resolution separately?
So, but they have preferred division only on.
State does many things, but they have to take the benefit of them, they have to take the permission for that. Have you taken the permission here?
No such permission.
No. This petition should go on that basis. Don't you think so?
Because of that particular effect, which I got the notice of the lordship. But the court was not happy in filing three petitions against the common.
Good. But then we will apply that, and that CAV judgment which is there for their reassessment, we dismiss the two for not filing one.
Those were different options. Those were not common.
So what? Why you are filing differently?
So, there are separate orders in the-
No. This type of practice is not expected. More particularly in tax matters. What provision? Don't further spoil your case, Mr. Kansal. You have already spoiled dented your case too much.
So I didn't have anything to spoil.
Don't
Whatever-
spoil what
whatever was there, I was
Mr.
expecting.
D. Chaudhary has already submitted.
Lord sir, this, as far as eligibility certificate, Lord sir, the eligibility certificate was granted under the Assam Industry Sales Tax Concession Scheme 1997.
Yes, then
Only that point, Lord sir. I mean, may kindly take up this, reply. Yeah, reply.
tell me.
That provision, Lord sir. The
Hmm.
period of validity of eligibility certificate.
Hmm.
The eligibility certificate, once is issued, is valid only for 7 years. So they are 7 years, that's what I just wanted to point out.
You are saying they are not, because they have not. But the question arises is whether without the certificate of entitlement, would they be entitled to?
So they are- So this is also the 7 years validity certificate.
Hearing complete judgment.
As regards entitlement certificate, there is an application of the petitioner, the first step pending very often. In the appeal as well as division, the specific ground.
But Mr. Saraf, you have not challenged the action, keeping the settlement assessment, the application for entitlement pending. You have not challenged. Then-
Inaction. But what should, they would have rejected, that would have given.
Is it required to be rejected? Is it required to be rejected? No. It says that a certificate of entitlement would be issued. It is not required to be rejected.
What should I have? Who is naming that
But Mr. Saraf, tell me one. Yes, those judgments which categorically say that the benefit under the scheme can only be given if it fulfills the conditions. If that be so, without the certificate of entitlement, can you get the benefit?
If you don't give the benefit, then they would not touch the assessments.
Huh?
For touching the assessments, they have to.
Why?
provide the application for-
No. Question of, are you saying that the assessment cannot be done without the certificate of entitlement? That is another aspect of the matter. Certificate of entitlement, just for example, if you see the entire scheme, in a case where your application under the sales tax concession scheme, that is why I read 10, is pending. And an application will be required from that authority out there saying that it is pending, and for 6 months only you are going to get the benefit of the remission.
Portion, that provision is portion of one provider liability that are not my eligibility certificate was not because granted to me after verifying.
Eligibility, what is your eligibility to get? Was as per the sales tax exemption, which was being granted. Now that is the policy. Now you have not challenged the remission scheme, but the remission scheme categorically says that without a certificate of entitlement, you cannot get it. Matter ends there. So what? But can you get, no, tell me one thing, can you get the benefit without the certificate of entitlement? No, matter ends. There is nothing else. That is another thing, but you are not challenging that action. You are only challenging the action of the assessment orders. I'm not concerned with those. That is not the subject matter of this writ petition. The writ petition here is very simple. It is to the effect that those assessment orders should be set aside and quashed. The reason why? Because you are entitled to the benefit under for getting the benefit of the remission. Now the question is, the assessing authority or even the revisional authority did not take into consideration that you are entitled to the remission. But to be entitled to the remission, you have to have the certificate of entitlement. Better ends. Nothing to should I dictate now? Enough, Mr. Shah. There's been a hearing concluded, there's been reserved.
That aspect has not been taken care of by the revision authority.
Not necessary. So, next.
And number 4 and 5.
Madam, you file your affidavit. You file your reply. Now, where's the railway? Yes, what do you have to say? They have filed an affidavit, additional affidavit, bringing on certain things. What is your stand? Yes. Because if I pass this order in his favor and in the favor of the petitioner, this would benefit you also. Because the railway can't impose upon you in view of Rule 126. So the effect is the railway.
But one difference remains on our part. The containers which contain those iron ingots not damaged in the intent. So that
Then they will file suit for damages against you. That their liberty will be given to them.
for that purpose,
For getting 20 lakhs of 6 lakhs, you have damaged the quantity of 53 lakhs.
but I have to take the container, one container costs around 1 crore or 2 crores, something like that. So that's that for that I have even filed an IE law.
For what?
For release of the goods from those containers, but that is still 20%.
That's not necessary. Why should I go into this higher business now? We can dispose it of matters. Where is Mr. Arcade Chudri?
So it's not good, but let the act also. The MRH and purchase charges are still in the.
But if you cannot levy, you cannot impose. Can you impose a demurrage charge upon them? On the ground that you are holding to the consignment, by virtue of section 74, and say that as this petitioner, yes, Mr. Architect Chaudhary, what do you have to say on this thing? Because as per Rule 126, 1B, You have not looked into? Huh?
I've gone through it this morning.
Okay, we take it up at 2.
Yes.
Look into it.
Number 6, permission. 6.
Here, charge sheet. Have you got it? Yes, madam. Charge sheet has been submitted. Anything you have to do, you take it up before the Chief Judicial Magistrate. Who? Was I? Take it up there. And as regards any compensation that the court will decide under 357E. Right? The instant petition was filed by the petitioner, has been filed by the petitioner. Seeking a direction upon the respondent authorities to produce the husband of the petitioner who was kidnapped, abducted, and remained untraced since 13/12/2014, and in respect of which Lanka PS case number 583/14 have been registered under section 328, 365, 34 of the Indian Penal Code dated 15/12/2014. As well as for compensation. From the materials on record, it reveals that the charge sheet in respect to Lanka PS case number 583/2014 was submitted by the investigating officer on 28/5/2022, and the same was received by the GR branch on 5/9/2022. It is further seen from the report submitted by the Chief Judicial Magistrate Hosai that on 29/8/2023, the charge sheet was put up for which was put up before the court of the Chief Judicial Magistrate Hosai, and cognizance of the offence was taken under section 365, 302, 34 of the Indian Penal Code against various persons whose names appear in the charge sheet. Today, when the matter has been taken up, Ms. M. Bormon, appearing on behalf of the respondent authorities, placed before this court a copy of the charge sheet number 120/2022 pertaining to Lonka PS case number 583/2014. Taking into account the above, it is the opinion of this court that there should not be any two parallel proceedings. The above, this court is of the opinion that as the matter is presently being taken up in the court of the Chief Judicial Magistrate Hosai, the petitioner would be well advised to approach the said court in the said proceedings. And would be at liberty to assist the PP. It is also seen that the petitioner have sought for certain compensation. Taking into account the provision of section 357A of the Code of Criminal Procedure 1973, the learned trial court shall duly consider as to whether the petitioner would be entitled to the compensation in terms with section 357A, read with the Assam Victims Compensation Scheme 2012 at the conclusion of the trial. With the above, the petition stands.
Seven is concerned by the chapter it doesn't cover so for the identification of cases are concerned. Actually, that chapter covers only for trial and courts jurisdiction matter. That probably will not be correct if you see that it includes investigation.
No, but what do you say about 156.1?
That's already there. That chapter
No,
is
156.1.
of chapter 13
Understood.
is that is not my last 14.
No, chapter 13 pertains to inquiries and trials.
Absolutely.
We no quarrel with that. But
Jurisdiction of criminal courts in
Yes.
the trial. And here this chapter 12 minus includes investigation.
so, but what do you say about 156.1? It makes a reference to chapter 13.
Any officer in charge of a police station may, without the order of the magistrate, investigate any operator case would having jurisdiction over the local area within the limits of the station would have power to transfer into or try under the provision of chapter.
So thereby this jurisdiction is goes from there.
Here in this case, my lord, it is not that in the FIR, like zero FIR cases, as I have understood, then suppose the person say that the crime has been committed in say Meghalaya or Tripura, my lord, then it is disclosed the commendable case, my lord, that police is bound to register a case. And accordingly, he will but 4 weeks prescribe it to the court, to the police station having jurisdiction. But here in this case, he accepts the FIR, case registered, investigates the matter, subsequently it is rectified. Much ahead was made, arrests were made, clearance claims were taken. So the process of criminal law was in motion.
No, therefore I am saying
Yes.
that it was illegal.
Yes.
Let us assume that it is a illegal or a nullity. But if the place of occurrence as per them had happened within the jurisdiction of Nagpur police station, and an investigation was done in view of 154 on the basis of that information. Investigation was done and a charge sheet is submitted. Can this court hold that the charge sheet and the trial which has been completed to be honest?
To be honest, here it will be difficult because
Because that will have another, because then you will be hitting upon 154, 54.
Yes.
54, the 154 says any information.
in that point, my lord, I could not make direct judgments, my lord, but certain judgments which have come to our court, my lord. Under such a situation, my lord, I was a little bit 1978 to SCC page 55. On the small Theravada. The Code of Criminal Procedure clothes is code with the power under section 406 to transfer a case or appeal from one high court or a court subordinate to one high court to another high court or to a court subordinate thereto. But it does not close this code with the power to transfer investigation from one police to another in the country. Simply because the first information or a remand report is forwarded to the court. The application before us stems from a misconception about the scope of section 406.
Understood, Mr.
Yes.
But the thing, what did the Supreme Court do in Navin Chandra GTS case?
Yes.
It transferred from Shillong to Bombay.
One case. Because that was also their observation was that whether police can privately go and arrest somebody.
No, the issue out there was everything happened there. And as such, there was a challenge there was an order being passed by the Shillong bench of the Guwahati High Court, directing the DGP and all these people to make an investigation and send a team to Bombay. This order, and pursuant to that, there were certain directions being passed, certain investigations were carried out. This investigation was put to challenge in Navin Chandra Miljitia. Bombay High Court dismissed it on the ground that no, we don't have the jurisdiction as it was an FIR which was filed out there. But what did the Supreme Court say? That whatever may be, let that all the investigation be brought to Bombay, because Bombay everything had happened.
That is where the ordinary occurs takes place. And the zero FI concept is also.
Now, as per this judgment, and even the Supreme Court under 406 cannot transfer an investigation.
And this 1993 criminal direction from Supreme Court minor. It is the same. There are 4 minor.
The last four lines says, if we analyze, a police officer from another police station,
Yes.
which had no territorial jurisdiction, can also record the information and then forward.
Yes.
That is
But
what.
here actually, as I have read in the entire matter, the place was not disclosed. They suspected he was in somewhere in Scotland. So that is the issue of that. That's why they raised that investigation, and during investigation, it came to like, the central jurisdiction come within the norm. So that is why. So my, with all respect, I'll submit matter, what was done is done already. We cannot now undo it, matter. But the fascinating two, three things, matter. The magistrate unfortunately acted in a very routine and casual manner. Because actually the investigation of a case is always reserved for the field of the investigator minor. Court should not ordinarily intervene. The police ought to have done it on their own. So they have taken the route of court, which probably is here. That's what the police to take up at their police level mind. And the second thing and the most important thing, I think, like I said, Rob was my last. Without issuing any notice to the informant party, the whole exercise was carried out. As they all lordship know, minor, as the final form is submitted, minor, so the report, minor, the notice is mandatory to refer to be issued. So that the person we agree to make after take his part of the matter. So these things were totally not followed, minor. So we might have to take care so that it doesn't happen. Otherwise, there may be chaos. And the major thing because quantity of might be for the easily made a reference to the 395 and 396. 395 clearly says, madam, if any major issue. Yes, then easily made a reference to this honorable High Court. High Court would have otherwise taken it or would have reflected the reference. Without taking that, this straightway in a routine manner, just simply by two lines written by the batch statement. He has done.
Mr. Khan, what do you say on the point which I have, the point which I have raised on the last occasion?
I make my.
Make your submission.
How can I take it?
But as per you, one thing, as per you also, once an information comes to the police station, and the police, rightly or wrongly, finds that yes, the place of occurrence was within their jurisdiction and submits a charge sheet. Thereupon a trial commences. This court cannot touch on that on a writ.
But then only that 177 of onwards chapter 13, because now it has come to the court. Here,
So no, therefore, thereupon, as regards the judgment in the by the trial court, an appeal will lie by the petitioner at best. But the question as to whether it was the place of occurrence here happened here or there cannot be adjudicated by this court on the 226 or even on the basis of affidavit. More so when the sketch map which is there, page 78 of that particular records, yes, shows that it happened as per them within the norm to police station.
no,
They can very well challenge those findings out there. Only I think now they have come to know about this thing.
Yeah.
Some liberty may be given to them for assailing it within the period. But I can't give that liberty because those courts belong there. But I can only say that they will only consider taking into account the pendency and they had no knowledge.
that's it.
Yes, Mr. Khan, what do you have to say?
So also after point out that the major didn't write the order of the strike two lines by the like to point that doesn't not allow body high court or related on I appreciate that the banks is writing the judgment for the orders and That should be. on
Was
the
it done by a division bench or a single bench?
Madam.
Was it done by a division bench or a single bench?
Single bench.
Okay.
So I remember that, but I don't date and that.
That was done when?
And when people discuss probably something in 67.
Huh?
67.
After 25 years,
What?
35
No,
years,
now-
I will retreat.
No, nowadays one thing, madam, nowadays it is all time, nobody knows who has typed it, what has been done. Because ultimately signature is there, but earlier it was written by hands, so that's why that practice was definitely. Because your lordship asked us for.
Hmm.
Much more.
Thank you.
My lord. On the last occasion, my lord, the question, my lord, issue, my lord. Whether transfer of the investigation by an incompetent court would initiate the investigation carried out by the local police station or even initiate trial more particularly, taking into account section 462 of the CRPC. Now, my lord. Section 462, my lord. Proceedings in wrong, no finding, sentence or order of any criminal code shall be set aside purely on the ground that the inquiry, trial or other proceedings in the course of which it was arrived at or passed took place in a wrong section division, district, subdivision or other local area. Unless it appears that such error has in fact occasioned a failure of justice. So, my lord, there is a error. If there is a failure of justice, my lord, the benefit under section 462 cannot be given to the accused. Now, but I try to place certain judgments, my lord, where my lord 460 says, my lord, the conditions under which the proceedings will be initiated. Irregularities which 460 says irregularities which do not initiate proceedings, there are certain. 461 says irregularities which initiate proceedings. Now, my lord, the transfer of the case by the magistrate not having jurisdiction is not included either in section 460 or section 4. Now the question arises, my lord, more particularly section 461, when it says irregularities which initiate proceedings. Now the question, the issue here is whether this list from A to Q is exhaustive or some other aspects also can be considered. I will place on that. First, we have to see, my lord, that whether this list is exhaustive, whether court can or whether court can go beyond this list also. So, my lord, I will take certain judgments and I just give it a second.
Yes.
The bottom iron part is number final. Page 1, my lord, is Atmaram and others versus State of Rajasthan 2019-20 SCC 481. Now, my lord, can we come to running page number 50?
Yes.
It is 495 of Atmaram.
Hmm?
Page number 495 of Atmaram.
Hmm.
Paragraph 19, my lord. At the bottom, my lord, from bottom, my lord, fourth line, my lord. Chapter 35 of the code deals with irregular proceedings, and section 461 stipulates certain improvements or irregularities with state proceedings, bearing those stipulated in section 461. The thrust of the chapter is that any improvement or irregularity would not state the proceeding unless as a result of such improvement or irregularity, great prejudice has occasion to the accused.
The accused.
My lord, in this case is the information. Now, my lord, another judgment, my lord, okay, running case number 22, my lord.
Yes.
My lord, this is figure versus state of Gujarat, my lord. kindly come to page 34. Running page number page 34 and 496 of the judgment.
Hmm.
I will just point out the submissions that was made at the bar and the conclusion arrived at. Page 20, para 21, my.
Hmm.
Shri Tushar Mehta, Learned Solicitor General of India, submitted that in view of the pronouncement of law by this court in Bharat Shanti Lal Shah, subsection 5 of section 20 of 2015 Act, will not by itself be an impediment in the way of the appellants getting defaulted. With the permission of the court, he made additional submission. He relied upon section 461 CRPC, which contains an exhaustive list of irregularities that vitiate proceeding. He asked that the irregularity alleged in this case is not a part of the list of the irregularities contained in the said provision. He also invited our attention to the subsection 2 of section 465 CRPC. So, my lord, the submission at the bar was that this list is exhaustive and court owner cannot go beyond that. Now, para 22, my lord. 1, 2, 3, 4, 5, 7th line, my para 22. We submitted that the failure to produce the appellant on the date on which extension application were heard is a mere irregularity in the proceedings which will have no effect on other cases such as cognizance, trial, etc. Now, my lord, page 46, running page 46.
Hmm.
Para 45, my lord, from bottom, from below, my lord, 1, 5th line, my lord.
Hmm.
Para 45, last part and reading. The failure to procure the presence of the accused either physically or virtually before the court and the failure to inform him that the application made by the public prosecutor for the extension of time is being considered is not a mere procedural irregularity. It is gross illegality that violates the rights of the accused under Article 21. Now, my lord, I place a judgment which says that right to fair investigation is also right under Article 21. Kindly come, my
No,
lord.
just before that, come 3 lines before what you have read. The procedure contemplated by Article 21 of the Constitution, which is required to be followed before the liberty of a person is taken away, has to be a fair and reasonable procedure. In fact, procedural safeguards play an important role in protecting the life, liberty guaranteed by Article 21. The failure to procure the presence of the accused, either physically or virtually before the court, and failure to inform him that the application made by so and so for extension is being considered is not a mere procedural. So this is in respect to the rights under Article 21 of the accused.
My lord, the question of right under Article 21 had come before the court.
Hmm.
Court said that we can go beyond that resource.
Hmm.
So now, my lord, page 49, my lord.
Yes.
Ritu Kumar is judgment, my lord. Kindly come to running page 55. Running page 55. So from the top, my lord, 7th line, my lord. A fair investigation is as much a part of a constitutional right guaranteed under Article 21 of the Constitution as a fair trial, without which the trial is naturally not be fair. So, my lord, what I am trying to show that when the question of right under Article 21 came, we can travel beyond this mind. And right to fair investigation is also a right under Article 21.
But here the reference which have been made to those judgments are all judgments of the trial court or the court of appeal or the high court in the court of appeal. Not under 226.
My lord, now, my lord, the FIR was lost under the jurisdiction of the high court. The dead body was found under the jurisdiction of the high court.
No, that is the problem. Whether it has been found is not what has been stated out there, even by the police. The place of occurrence has happened at Longpur.
Now, my lord, we are under section 462, my lord. Whether the proceedings will be initiated or not.
No, I'm not on that. You see, here is a case. An illegality has been committed in transferring an investigation by an authority or by a court which did not have the power to do so. There's no quarrel with that. I've already stated in my order that that is wrong. But once that information has come before the officer in charge of the police station or the police station concerned, and that information need not be an information in terms with section 154. And if that can be considered to be an investigation, why can't the police investigate and submit a charge sheet? And if the charge sheet has been submitted, the court can very well, rightly or wrongly, pass an order. If a court has rightly or wrongly passed an order, the only remedy which may be available to you is to file an appeal. And not by way of a writ proceeding. What you are asking, in fact, is to hold that it is a murder investigation. You are asking that this court should hold it to be a murder investigation and also penalize those the respondent number 14 to 18. These are things which can only happen if at the end of the trial or in an appeal you have challenged, it is held that yes, the investigation has been a botched up investigation. And then on the basis thereof, you can very well come before this court.
The FIR which was registered at Rangpur, it followed from 154. They registered the FIR on the basis of the FIR submitted by the petitioner.
Yes.
By the petitioner, then they carried on investigation. Now, the stand of the petitioner, the petition is there. The police at Palasbari, the police at Rangpur, and the accused person were hand in glove. And they have shown this case of murder as now, I take the lordship to other judgment. Now, lordship, if lordship presumes that that investigation is correct, the facts.
I'm not going to assume anything. Because the moment I assume or presume, that has to be based upon certainty. But an order has been passed, an investigation has been done, 302 FSRC has been submitted or whatever, maybe the court had given them a punishment under 304. No. The fact that the investigation was duly carried out, rightly or wrongly, but unless that court holds something, which in the normal course of events is that court, why should this court under 226 interfere?
Now, my petitioner came before this court, and this can is that first that we lost the affair under the system of this court, and that was illegally transferred, my lord, and then they acted hand in glove and then have done so it is an accident. Now, my lord, whatever happened now, my lord,
Illegally transferred by whom?
by the magistrate concerned.
The magistrate had done it. You may make the magistrate a party.
Oh, my.
Then
Now, my lord, what happened, my lord? Now, only remedy, my lord, available to the respondents, my lord, is under section 462. That is guarding them. 462 says that if there is a failure of justice, then court can interfere. Now, to look at that, my lord,
No. They are not saying about 462. The question of 462 only comes in that if the investigations have been done, merely on the fact that there was at one point of time an FIR being filed here and there was an illegal transfer being made, put it in view of 462, whole, their entire proceedings is bad.
my lord, may I take the lordship to some judgment, my lord? Page 60, my lord. 2010 and 59. I don't may kindly come to page 69.
Page?
Page 69.
Yes.
There are 17, my lord. As seen from the pleadings and the rival contention, the petitioner took transfer primarily on the ground of lack of territorial jurisdiction. While the question of territorial jurisdiction is civil cases revolves mainly around cause of action or location of the subject matter of the suit or the residence of the defendant, etc. According as the case may be, the question of territorial jurisdiction in criminal cases revolves around fixed of commission of the offense or case where the consequence of an act, both of which constitute an offense ensuing, place where the accused was found, or place where the victim was found, or place where the property in respect of which the offense was committed was found, or place where the property forming the subject matter of an offense was required to be returned or accounted for, etc. According as the case may be. So, my lord, here the accused was found at Palasbari, victim was found at Palasbari. My lord, the police here.
Mr. Khan, repeatedly I'm telling, there is no quarrel. This court is not saying that the order passed by the officer was right, or even by the judicial officer was right, or the application was right. I've already stated in my earlier order that it was, let us assume that it is a knowledge. But the fact that there is an information which is available, and it has been investigated upon, and a charge sheet has been submitted and then which ended in a trial, can this court under 226 now again direct this investigation in respect to that case, which has already been investigated upon? A trial has happened, more particularly in view of that 300.
My lord, yes, if this court is satisfied that there is a failure of justice. Now, my lord, to pass any order,
Failure of justice for what?
my lord, you see, for that, my lord has to enter into the facts. Without entering into the facts,
There the problem arises. Otherwise, till that point, sending from here to Nongpo, this court is absolutely with you. Thereafter, the problem
sending
arises.
the case from here to Nongpo, whether it is sufficient failure of justice, whether the allegation brought in by the petitioner in the petition can be accepted, prima facie it can be accepted or not. That has to be seen, my lord. Without entering into the facts, my lord, no order can be passed. That's why lordship has to enter into the facts. And what happened? What was the circumstances? If this court does not enter, my lord, you cannot expect Meghalaya High Court to enter. Because, and moreover, my lord, we had called the FIR here. No, during the entire investigation, we were never called. Our statement is not recorded. We were not informed that it is being transferred, my lord. Now, my lord, and we allege, my lord, with all documents, my lord, that this investigation is not fair, and it has in fact occasioned failure of justice. Now, lordship has to enter into the facts of the case to see whether my allegations can at all prima facie be believed, whether whatever allegation I am bringing in, whatever allegation I have brought in, my lord, whether this court should at all entertain or not, or these are vague. On the face of it cannot be accepted. I have mentioned, my lord, and my lord, so one judgment, my lord. In my writ petition, my lord. Paragraph 21. I have mentioned, lordship has, whatever I have stated in paragraph 21 has to be examined, my lord.
How?
Fine.
How? How it can be examined by this court under 226?
So, my lord, to complete justice, my lord. But we have no other option, my lord. Only 226 is available, my lord. And we fall under the jurisdiction of this high court. Dead body was found under the jurisdiction of this high court. Now, my lord, they are saying that accident took place in Meghalaya, my lord. Dead body was found at Palasbari, Assam, my lord. This court has jurisdiction, my lord. That's the judgment I have read just now, paragraph 17, where the victim was found, where the accused were found. Victim was found here, accused was found here, case was under the jurisdiction of this court, taken up from the jurisdiction of this court. Now, this court has to see whether it was rightly done or not. Case was under this court, my lord. This court had a hand on the case. They have taken it out, my lord, from this court. Now this court has to monitor whether it was rightly taken out or wrongly taken out. This court has to see whether 462 will apply. 462 will apply if there is, it will apply if no failure of justice is done. If we prove that there is failure of justice, then this court has to interfere. And for that, my lordship has to enter into the facts of the case. What we are alleging, whether these grounds are at all acceptable, whatever we have written here, or these are just our imaginations, just is our what we think, my lord, imaginary things, or if we have talked on basis of some facts, my lord, has to see. Without going into the facts, my lord, we will not get relief. No court can give us relief if the facts are not entered into. This is a my lord, heinous crime of murder, my lord. Now we have brought in all the facts before this court to show that this is a murder. On the other day, when the record came, my lord, I have seen the vehicle, my lord. Vehicle is intact, my lord. There is not even a scratch on the front glass, my lord. And you kindly see the injury sustained by the accused person. No other laborers were injured, only this laborer had died, my lord, with such grievous injury, my lord. Kindly see the photograph of the truck, my lord. That is questionable, my lord. Moreover, my lord, all the statements are different. In 161, driver says that the vehicle capsized on the roadside. In one statement, he said that vehicle fell down on the field. Two different statements. In one statement, he said that dead body of the victim was carried from the place of occurrence. In another statement, he said the victim died on the way to hospital. Then, my lord, they have filed their affidavit. They are also a contradictory stand, my lord. Victim was not taken to the hospital. My lord, the local police station had no information that such accident had happened. They said that accident took place at Maksar village, Maksar or something. Now, my lord, whether any villagers of their village has been examined under 161 to prove that this is an accident, only the accused persons, my lord, have been, only the accused person has been examined, my lord.
You are saying by them,
My lord,
the
By none, my lord.
the investigation properly not done by whom?
both police station, my lord, they have managed.
No, from here to it was sent. From here to it was sent.
It was sent after managing the police file.
Whatever may be, but it was sent. Now, the sending was wrong.
Sending was
This code is with you till there. But the problem arises is, once it has gone there, if the investigation has been done wrongly, can this court in 226 out here hold that the investigation done by a Nongpo police station was done wrongly?
has to see. My lord, we are saying, the petitioner is saying that the mother.
Or is it because the baby was born here, so we have to take care of the baby there?
Not because of that. Specifically, we have stated, my lord, that the murder happened at Palasbari.
And what is their charge sheet?
My lord,
What is their charge sheet?
my lord.
What do they say in their charge sheet? Where did it happen?
They say that it's Nongpo.
It is what? This is a question of fact.
They are challenging that, my. They are challenging that, that is the petition, my lord, before this court. And under 462, my lord, this court can see whether it has occasion failure of justice, and for that, court has to enter into the fact.
No, 462, can this court exercise here? In view of the Meghalaya High Court being there.
My lord,
You see, the investigation has been done wrongly there. You see, the problem which I am facing is this. I have all sympathy for you. I have initially from that moment, the moment I have taken up the matter, I have taken up. You see, what you are asking, that a trial has been committed there. A judgment has been passed there. This court cannot exercise a jurisdiction over that order, as it is the Meghalaya High Court or the district judge who can at best. So that remains as one. On one hand, you are asking, other hand, you are asking that again, you investigate this particular case here. Now, can there be two investigations in respect of one offense,
these are proceedings, my lord.
Huh?
Proceedings.
which have already
It
culminated?
happened after the transfer, my lord. These are all the part of proceedings, my lord. And I am challenging the entire proceeding. 462 says, if it has occasion failure of justice, entire proceedings will go.
462 says the entire proceedings will go. There's no quarrel. But who is going to look into it?
My lord, now I cannot go to Meghalaya High Court and say that. Madam,
Why?
you
It's
take
too
it
far.
in Assam, so send it there, my lord.
No, you can very well appeal before the district judge or whoever may be, or even go to this, the Meghalaya High Court and say that you see that. But I think the best option is to go and show that yes, the investigation was done falsely. That is another aspect. But the fact that can this court now direct up an investigation in respect to a case which have already been investigated upon by another police station.
My lord, all proceedings will be initiated if this court, after going to the facts, is satisfied that yes, it has officially taken of justice. Entire material is before the court. Entire material, my lord, case diary, entire case record is, if this court is satisfied, then court can go into it. My lord.
Now tell me, what would be required for directing a de novo investigation by the Polasbury police station?
Not by the CBI, my lord. We are asking for CBI.
Let us go by the CBI or whatever, whoever does it. What will be required for this court to again direct a re-investigation in respect to that offense?
My lord, this court, since the petitioner is saying that the murder has taken place at Palasbari, subsequently shown as an accident at Nongpur. Now, if this court has passed, this court has to be satisfied that whether the allegation is on illegal or not, on going to the record. If this court thinks that yes, whatever the petitioner is saying is believable, and then this court can directly. 462 will come in, entire proceeding will be initiated.
Which one?
If this court, my lord, after going to the record, finds that
No, 462 would not come in. 462 saves. If there is any irregularity, it's saved, unless it's occasion failure of justice.
my lord, first we should be able to prove to this court that it has in fact occasion failure of justice. Now, how do we show that without going into fact?
But can this court do it, not the Meghalaya High Court?
No, my lord, this court, because my lord,
Because the baby was born here.
not mine.
Then what?
It's not baby was born, my lord, but
Then why?
offense crime was committed here, my. Dead body was found here, my.
That is, you are saying, he is not saying that.
My lord, I am the informant. It is my case, my. They have made up the.
Let us see your FIR. What did you say? That the body was found.
Page 44 of the litigation, my.
Yes.
Respectfully, I would like to state that my son, Vilas Kumar Das, was not in at home since 5:40. Today, on Tuesday, 6:40, at about 5:30 AM, Sri Pandava Kumar Das and Sri Nava Kumar Das, son of Sri Namala Kanta Das of Amranga, Medipara Gaon, got my son's dead body in a Bolero pickup van and told us that yesterday at about 1 AM, somewhere at Patharkhama of Meghalaya, my son had met with an accident and died. But we doubt that the above mentioned persons murdered my son in a planned manner and gave it a color of accident. Therefore, sir, it is the confidence.
So where is it? You are saying that it had happened at Guwahati, in Assam.
The facts and circumstances state so, my lord.
Where?
That my lord, lordship has to permit me to show. So I will try to satisfy lordship that the story, now my lord, murder has taken place, my lord, person 15 at time. Now, my lord, it is the accused person who has to explain the death,
Why?
because my lord, they are saying that it is an accident at Patharkhama, my lord. Since they are saying, they have to satisfactorily explain
Before whom?
before the court, my lord.
Which court?
My lord, now, my lord, first of all, it was
Trial
by the
court.
magistrate.
A magistrate or trial court, whoever it is. He has to
My
explain.
case is that, my lord, since my lord, these proceedings was illegally transferred, my lord, I raise my right under Article 21, so it will initiate the entire proceeding, my. That is my line of argument. And whether it will vitiate or not, now court has to see whether it is operation failure of justice supported and the record has to be seen by the case, my.
What is the failure of justice?
Yes, my.
Yes, tell me, what is the failure of justice? That you could not participate.
I could not participate, that is one thing, my lord.
Yeah.
And secondly, my lord, the facts which they are stating, my lord, is whether it is at all believable.
That is not for this court to decide.
My lord, this court has to go on and see, my lord,
No, no, no.
what they have done, my lord. Because my lord, FIR was lodged here, victim dead body was recovered from here, so if not this court, my lord, then no other court has.
What is your basis to say you have not stated a single word out here in your FIR?
My lord, FIR, my lord, is, my lord, FIR, my lord, stated that he has a, code of action.
In your FIR only you say those
No.
people came and informed you that it happened at Meghalaya.
Yes, my lord, we say that we doubt that it is murder, and when they did not give us a.
Okay, okay, Mr. Khan, I will hear you later. Yes, Mr. Mohanto, tell me. You repeat.
This is even 462.
Uh.
The lordship kindly see, admittedly, my lord, on the basis of this FIR, so we can conclude that my lord judgment has been passed by the trial. Their judgment, my lord, this honorable court has no power to say the
Yeah.
same.
No, not only that.
And my lord,
That as regards one incident, occurrence or a crime which has been committed, an investigation was carried out which culminated into a trial and a judgment.
exactly, my lord.
Now, can this court direct?
Then my lord, it will be the 300 year lordship kindly see.
That is what I'm saying, 300.
Until and unless that has been set aside by the competent court,
There the
then he
problem.
cannot, my lord, apply for, my lord, further investigation. Yes, in a law can be, my lord, but when? It has to be set aside. First, it has to be set aside.
No,
But who will say-
tomorrow, just for example, the appellate court holds that yes, the judgment which have been delivered was not done properly or
Yes.
investigation was not done properly. Then he can come before this court and ask for a direction in a writ of similar nature for a fresh investigation, taking into account that it was not properly done. That in many cases which you find in criminal law, where the investigation was not done properly, for which it had led to an acquittal.
First, my lord, the judgment has to go, my lord.
Absolutely. Without that,
We cannot.
if I ask another thing, wouldn't that be opening up another investigation, which may at the end of the day may lead to a charge sheet and another trial which he had already gone through.
So that's why 300, the lordship kindly said, how we can overcome fear. 300 is for the same offense file. If after the investigation it is found that it is not a case of 304A but 302, then it will not be the same offense. Or on the basis of this FIR, now I have done for him, yes, he himself pointed out that cause of action arise in Meghalaya. I said that they have stated. So from preliminary, all right, he has a very good ground for minor appeal. These are the things happen here, yes, right, very wrongly minor sent by the minister.
And for that,
But
it may vitiate
yes.
for failure of justice.
Yes,
That is the
that's what-
case
no,
which the
that
appellate court may
462
decide.
line is there, madam. No finding, sentence or order, any criminal court shall be set aside merely on the ground that an inquiry, trial or proceeding in such case which was alive in the past took place in a wrong possession division, district, sub-division, other local area, unless it appears that such erroneous sentence occasion in favor of justice. So if there is a failure of justice, that can be minor set aside by whom?
By
By
the
Meghalaya.
appellate court.
What court, my lord? So that is minor ambiguity. That answer is there in 462. Court
But
shall not
how
be set
can
aside.
this court exercise 462?
462. Merely, yes, Meghalaya, in appeal, my lord, it can be exercised under section 462. It is set aside and the more can be made. That can be done. But not by the, not under 226. Yeah.
It will have a far-reaching consequences here. Because what is the conclusion you are asking? You are asking that there should be another investigation. Let us have hope for the best of your case to the CBI. The CBI submits a charge sheet, and another case is another trial is there. Can they, on respect to the same offense, not offense, same crime, Can't be. Because here your facts are okay, maybe very compelling. But if this is the proposition you hold, and if you put it in that place, think about other circumstances where it will all along, whenever a person is acquitted, it will lead to another proceedings for an investigation. It will be a non-ending of a criminal proceeding which is given as per the CRS.
Only if it is only there is figure of justice fund. That part has to be seen up with figure fund. That is the question which I asked myself.
Yes, Mr. H does. What do you have to say? You are the people who killed.
I'm for Balagram.
Now got away with 50,000.
13 madam.
Eh?
13 madam.
5 to 13,
That
yes.
driver has been already convicted madam.
Convicted of what? 50,000.
Phase 102 madam. Phase 102, there madam says that madam. Accused Moinul Ali is present in the court today and submitted petition sitting in the only supported by an affidavit. BA registered the same particulars of the offense under section 2794/27/304A. IPC shall cited against the accused in the case limit stated to the accused today. Accused guilty of offense under section 1. Notice under section 251 CRPC prepared a separate sheet wherein accused has pleaded guilty, put on record upon pleading guilty, accused is hereby convicted of the offense under section 279 and is sentenced to payment of ₹1,000. Accused is convicted of the offense under section 447 IPC and is sentenced to payment of ₹20,000. Accused is also convicted of the offense under section 304A IPC and sentenced to payment of fine of ₹4,000. Accused has paid the fine to pay 7,000 at Meghalaya receipt number so and the same is to be forthwith deposited in the state treasury under the head of the account. Fine and forfeiture of the mentioned staff accounts officer days so these materials are also as per materials on record has been released on the month shall remain in the custody of the registered owner hereof. Case is disclosed.
Show me one thing. Where's the charge sheet?
Search it, my lord.
You have enclosed the charge sheet?
Yes, yes.
Yes.
Page number 71. The person laying down the search sheet, my lord, is not even visited himself.
Hmm?
The officer who laid down the search sheet,
Hmm.
he did not visit the place of occurrence. He says during investigation, PO was visited by previous item. So and see Jagat Suti of Palasbari PS Assam, and also the available witnesses were carefully examined and it was ascertained that the case is purely accident case and not a case. Jagat Sutia is there, madam. He was very active there at Longpur, so it shows. No, madam, they are saying about a village, whether any villager has been examined.
No, understood. All these things, in fact, the manner in which the charge sheet has been given may be wrong. Absolutely. 304 shouldn't have been. It should have been 302. What do you mean? But the fact that how do you overcome this
No,
problem?
my lord, I go to Meghalaya.
No, for going to Meghalaya High Court also, you need a finding out here. To that effect, a finding from this court. That this court cannot exercise the jurisdiction in view of that. You need that to go to the Meghalaya. But the Meghalaya High Court may also throw you out here? Why don't you go to the High Court? Go ahead.
Because Meghalaya, my lord, now, when I take a stand that the murder was committed here in Assam, my lord, then again I cannot go and say the Meghalaya High Court or next.
But how can you see? Was your 161 statement taken?
Oh, my lord.
Was your
No,
160?
no,
So on what basis are you saying that the offense is taken at Guwahati or in Assam?
my lord,
Your only document was the FIR.
my lord, from the affair, we would not do this with my lord, right? We not found certain, my lord, facts, my lord, we showed that it is not existing. Only because of that, we have,
But on record, what is your documents?
on record, I have annexed everything, my
No,
lord.
no, no, not here. On record, what is your stand before any of the authorities?
On record, my lord, my stand is that, my lord, they have.
The FIR
FIR, my lord. that's
and
what- And go to the FIR, my lord.
no, I have gone to the FIR and nothing else. Yours.
My lord, fair investigation should have been provided to me, my lord. By the investigating agency, I have clearly mentioned, but we doubt that the above mentioned person murdered my son. It is there, my lord, murdered my son. I specifically mentioned that they have murdered my son.
Where?
In the FIR,
Where? That I know where.
at Palambari police station.
No. Meghalaya. You only say they informed it. Have you said, put a single word that the body was found at Meghalaya? At Polasbari?
No, my lord.
No.
No, my
Now
lord.
you are going to
And
say
told us
FIR
that-
is not an
No,
encyclopedia.
no, my lord, and the first paragraph of the FIR read again, my lord. Respectfully, I would like to state that my son, Sri Vilas Kumar Das, was not killed at home since 5/5/14. Today on Tuesday, 6/5/14, at about 5:30 AM, Sri Kandalpa Kumar Das and Sri Nava Kumar Das, son of Sri Kamala Kandra Das of Amranga Medicine, now got my son's dead body in a Bolero pickup van, so and told us that yesterday at about 1 AM somewhere at Patharkhama of Meghalaya, my son had met with an accident and died. This is not my version, but I'm stating their version in the FIR. Then I further state, my lord, but we doubt that the above mentioned persons murdered my son in a planned manner and gave it a color of accident. I never say that, I never admitted it's a Patharkhama. I just say what they told me by the.
I'm not saying that you have admitted, but you are saying, but where have you said that it is at in Assam? Where have you stated? Is there anything on record? Where were they? Before either the investigating authorities or anybody that it happened at Guwahati and in Assam? No, because your 161 was not taken, that is your stand. Except stating out here in a writ. Where have you stated? Ah.
That is my lord. This will come out in investigation, my lord. Now I will state, my lord, how, my lord, the things which they have stated, my lord, whether it is acceptable. Now, my lord, suppose, my lord, what they have said.
If I take a criminal roster, I will take up all these things. Those aspects, but not now. Here, I am taking 226. Limit your consideration to 226. I am not going to consider how the investigation was carried out. Yes, if the investigation was wrongly done, if it was done in Polasbari, I would have very well said, yes, this is there. But then also, this court would have exercised that jurisdiction. But for the purpose which was happened out there in Nongpu, how can this? And that ended in a trial with an whatever punishment which have been imposed.
That, my lord, the trial, my lord, nothing happened. He just pleaded guilty and went off. No witnesses were recorded. There is no finding of the court that this is a case of accident, my lord. No court finding is there on that point that this is an accident. No trial in fact was
He
there.
was happy with paying 11,000 and getting off instead of spending so much of money on Mr. H. Das now.
Whether, my lord, now, my lord, it was between the police and the accused person. Police have sent the case from here to Nongpo. Nongpo police said this accident, accused appeared before the court, paid a fine of 7,000, went off money. The matter, the case of the petitioner was not before any court for examination, for consideration, for appreciation of evidence. Did not get an opportunity. This case, my lord, had ended in this manner, my lord. No court would apply its mind to the facts and circumstances of the.
No, you addressed me on one, which was already there on the last. Whether the investigation could have carried out by Nongpu police station on the basis of on the basis of an illegal transfer.
No. That's what what I have. Stated.
Yes, show me that. If it is no, then you have a case.
My lord. 462 is proceedings in wrong place. No finding, sentence, or order of any criminal code, that is the non code, shall be set aside merely on the ground that the inquiry, trial, or other proceeding in the course of which it was arrived at or passed took place in a rock session, division, district, subdivision, or other local area. So my lord, it cannot be set aside, but the writer says unless it appears that such error has in fact occasioned the penalty. Now, my lord,
Mr. Khan, you come to the point which I have asked.
my
You have already argued that you are saying about failure of justice or occasion failure. That is for the Meghalaya High Court to look into it, or the district. This court cannot touch on that on 462 as regards setting aside that thing. No, this court won't. You are to, therefore, I am asking you again, whether the investigation could not have been made on the basis of that transfer. That is your case. If you can make out a case on that, you have it, otherwise you don't. Materials. Isn't it, Mr. Monta? Huh? No. His pleaded case is different. His pleaded case was entirely on the basis of this was illegally transferred and all these things. Yes, it was illegal. But the fact that it being an information and from the materials on record, it prima facie shows that the place of occurrence had happened. Wouldn't under 154 the police have the jurisdiction at Nongpu? And if the police has a jurisdiction, being a cognizable case, the police can investigate, even with an illegal information. Now, therefore, I am asking you that even assuming, asking him that whether such an information which has been passed by a court, which has arrived there before the officer in charge of the police station, and Nongpu police station, on the basis of an order passed by a court which is non-est, can be, on the basis thereof, an investigation be carried out. I am of the opinion, yes, because 154 does not distinguish any type of information. It says about information. So he is to therefore show me that. You need time,
just on one point.
but don't repeat again 464.
No. Now, my lord. FIR was taken under section 150. Now, my lord, hereafter, my lord, it should have ended, my lord, on a report. Either final. Now, my lord, kindly see what police at Nongpu they have done is 174 miles. They can come under, they can investigate under 174 miles, which says police to inquire and report on suicide, etc. Where the officer in charge of a police station or some other police officer, especially empowered by the state government in their behalf, receives information that the person has committed suicide or has been killed by another, or by animal, or by machinery, or by an accident, or has died under circumstances raising a reasonable suspicion that some other person has committed an offence, he shall immediately give information thereof to the nearest executive magistrate empowered to hold impaired, and unless otherwise directed by any rule prescribed by the state government or by any general or special order of the district of such regional magistrate, shall proceed to the place where the body of the living person is and here in the presence of two or more respectable individuals. My lord, this is 174. When, since it is a case of accident, my lord, even if the FIR is sent to Nompo police station, they will come under 174, they will submit the report under 174. They have not submitted, they cannot from 174, they cannot go to 170. 154, the FIR is lost under 154, it has to travel, my lord, and come to 173. Charge sheet has to be submitted, final form has to be submitted. When it is an accident, my lord, it comes under 174. Traveling, it is from 174, they cannot travel to 173, which they have done, my. Since it was under 154 at Palasbari, it should have continued. Police and Assam should have investigated the same, because place of occurrence falls here also. Because if at all admitting that something happened outside the jurisdiction, but dead body was traveled, my. Dead body was brought in, my. Dead body was found. At the place where dead body was found, it has jurisdiction. So from 154, it should have traveled.
Dead body was found where?
Palasbari.
How?
They
Brought the dead body.
the house of the
Tomorrow you take the dead body to the American police will have the jurisdiction.
my lord. It says,
My
my lord,
goodness.
the victim
Is
is
it-
found, my lord. Place of I have read the judgment.
Okay, would that be the place of occurrence where the dead body was being taken? Everywhere the Novograd, the Sanmai police station will have all over the people, or Bhutnath police station will have where his last rites have been done.
Found at a past instance, my lord.
The first instance is there where it has happened.
Now, my lord, we have to take that, my lord.
Or is it because the father has seen it at his place, therefore that police station will have the jurisdiction? Don't make that submission. We are on a very important point. This point, don't make it in such a manner. Let us see what 174 is. How do you bring 174 here?
My lord, when the police
174, just for example, and 174 is a provision which supplements during the course of investigation. In every case where there is a suicide, in every case where there is a person being killed, for the purpose of making the inquest, the magistrate, executive magistrate has to be taken into account, and that is the reason why 174 is there. A person just like me, who doesn't know the criminal law only would say this. Your answer, your question is specific. The smallest of the question, don't travel here, there, everywhere. Can, on the basis of an information which have been given by, or which have been received by the officer in charge, which is honest, or which was, information was provided without jurisdiction by the court, the officer in charge of that police station would be in a position to investigate. If it cannot, matter ends. If it can, simple point is this. And that was the question which was raised. The question of being a fair investigation, you are entitled to, there's no quarrel. Yes, you are. But can this court look into this? Isn't that, Mr. Mondo? That is the specific point.
And then, my lord, entering, my lord, that judgment has to go. That judgment has to, without going there, without setting aside that judgment by the competent court, there cannot be other illegal. So if they stand that that doesn't stand, my lord. That is absolutely bar under section 300.
There,
That, my
another
lord,
big problem with this 300.
the problem, my lord. That's why, my lord, in the proper code, it has to, my lord, say the same. Thereafter, my lord, everything open. He can, my lord, yes, he has a very good gown, he is a case, man.
I also think he
Yes,
has
my
a
lord,
case.
because your lordship kindly see, this is not a case of accident, my lord. Absolutely, my lord. But now, my lord, 462, he can, by applying 462, my lord.
There in that code he can.
My lord, or who has a jurisdiction, my lord, can say that. So these are the good ground for appeal, my lord, against the people.
And what do you say about our learned magistrate? What he has done? Have you seen that order?
Yes.
No. Have you seen this? No, have you seen this? See this?
Yes, committed a wrong, my lord. At least, my lord, you
Not
need a finding.
wrong. This is too much. See these two. I have flag marked it. First is the second flag mark is the petition filed by the SI. The second flag mark. He requests in the last of the paragraph, the last paragraph, he said that everything it will be for the best of the investigation of the word used. And see the order passed, the first flag. The last one. On that very day. No notice to the informant, nothing.
Yes, that cannot be.
What he has done, see.
In the prayer of IO, CP and that is allowed. Without issue of that. That cannot be. Then you will have such a situation, when situation arise, if my lord, you can exercise under section 295 to get the effect of the board, but see the situation about to do. It's already done. It's not done. But it is basic thing, man. And you send it,
And see the handwriting. There are two handwritings.
that is a minor for endpoint. Who has
You find out, see who is it, and inform this court, the person. You get the name of the person, we will bring him,
yes, that
because that is required. Because I think this is a case where strictures are required
that's fine.
against this person. First of all, what he has done,
That's absolutely correct. But now I have noticed.
this is not,
Same order, they are 200.
and if this judicial magistrate doesn't know the basics,
Yes.
that you cannot transfer an investigation. How, and that too, outside the state. I would have understood even the district judge, if you see 409, remember 409?
Yes, 407.
409. Yeah. The district judge can only transfer as regards within his district.
Yes.
And how can a magistrate transfer from here to there?
Yes,
And that to a case, here the investigation.
he send it to a jurisdiction, he's going to follow. So that might not be running this paradigm.
The matter have been heard at length. When after vacation, list the matter, you find out that is the only. Because I want this matter to be done as early because of the fact that it may help you in approaching the the appellate authority or even the Meghalaya High Court. Because unless this court says that this court cannot touch it in view of that, you cannot approach there because that court otherwise will throw you here. But it has been heard at length again and would be taken up for further consideration on 16th of November 2023. This court also had drawn the attention of Mr. T.J. Mahanta, the the Standing Council of the Guwahati High Court. As regards the order dated, Mr. Monto, what is the order 48/2014? 48/2014, whereby the concerned judicial magistrate of Kamrup, Amingaon, had transferred by Polasbari PS case number 183/2014 to the Nongpu police station. Taking into account the manner in which the said order has been passed, and that too without putting the complainant, the first informant, into notice, this court directs the Standing Council of the Guwahati High Court to apprise this court on the next date the name of the officer, judicial officer, who had passed the said order, and as to whether he still is in service. List accordingly. এইখানে ভৰাই দিয়ক, ভালকে থৈ দিয়ক। এই দুখন ভৰাই দিয়ক। এখন লিষ্ট এখন বনাই জাজমেন্ট, এইটো টাইম মুটাটো এখন, এইটো জেল কম। What is this? It has been done. Hey, more order is going to You have my earlier orders.
Yes, I thought,
No, my earlier orders which have been passed in similar matters.
yes, sir.
You don't have it. You have a number. Give a number of one of these.
I know.
In one repetition, how many years are here?
Well, thank you. You want to, idea.
Huh?
15 was the idea, but the ground has more document was provided by the, for another years, for 6 years.
So now these repetitions have been filed against SOCO's notices.
Yes, sir. Recovery of recovery.
Recovery notice. So these recovery notices will go and it shall be.
Covered by,
Now, which order is for which?
order number 3, pertaining to WCC number 5570.
Which one?
Order number 3.
3 is for 5570. Okay.
Number 2. For 5569.
What are disposed of?
Yes, sir.
That order, you have the number?
I'll find out that.
You give it to me. Itu amar mara hoise.
Yes, sir.
Mrs. A. Jane. A. Jane asil file sounds. Huh? Britannia. Britannia. Anyway, give the number.
I'll find out that.
The disposed, huh? To order to hit work milai dibo. I'll just see. None of them are there today. This group of Nitu, Haveli and all, they are not there.
I'll find out that.
এখন ভৰাই দিব দেই, এই ভিতৰত দুখন order আছে। They are marked as X দেই, ভিতৰত। X mark করে। Mind to যায়। Take it at 2. Mr. Goenka, your matter is there, na?
Yes, sir.
Okay, we'll take it up at 2. You've seen that? More particularly, a page, running page 120, 28,
That's it.
128 2. One and 26, 1A.
26(1).
If on arrival at the destination it is found that the goods have been improperly described and at a lower rate, then the correctly applicable has been obtained, charges at double the rate, class 300 rate, X rate will be levied by the. If in a consignment of packages chargeable at different rate, a group of packages chargeable at a particular rate is improperly described and thereby a lower rate obtained, the charge at double the class so and so, referred to in subclause A above, shall apply only to the group of packages in the consignment improperly described and not to the entire.
And it will be restricted only to the consignment yield property. As it is, so far as shipping first come to, when we take the worship to the consignor, we consign. Here, there is a consignor. He sends some good to this particular consignor. He also sends some good to other consignors. So far as the consignment is concerned, worship. In this particular case, if you relate to the consignment, say to the particular consignment.
Here the consignee is only in respect to that.
Yes. So the misdeclaration is it will not relate to this consignment. Yes, yes. It will not relate to this consignment.
Yeah.
And
So therefore, how can there be an imposition upon them on the basis of a guidelines, which can, because it is on the basis of that guidelines
now,
you have imposed.
now, here also, Worship, just my mind. If you worship and see, let us see worship page 120. This is a
120?
120, running page 120.
Yes.
This worship is definitely a amendment to Rule 26(1)(a) of those rules, which are published, placed before
Hmm.
the competent forum for approval, and there are very country matters. Now, if the worship will come to, this is the amendment of what your worship has just.
Read. This is an amendment to page 128.
So far as worship Rule 126(1)(a) is concerned.
C.
1A.
1A.
1A has been changed.
Hmm.
Now, I'm not on the worship this amended rule, but the worship will see this pertains to Rule 126(1). And now your worship will see the impute notification, impute this letter, dated 14/2/2011, that your worship will find it.
In the other petition. Which one?
1974 of it.
Yes. Where are you referring to?
Page 55.
Yeah.
The impute notification.
Hmm.
Now, what penalties sought to be imposed,
Hmm.
worship will see in clause 2.6. Now, this is a notification of if there is a change to the rules, it can be understood. From where this notification has come, it does not pertain to the. It has to have some source. It does not. And if you worship will see, in the rules, it is I'm just reading. If on arrival at the destination, it is found that the goods have been improperly described and that the lower rate and the correctly applicable
thereby obtain charges 4 times. The applicable state rate will be divided by the book fruit as shown on the related invoice. Now, this, in my humble submission, Lordship, this has to be read with the consignment. This has to be read with the consignment. These penal charges will be in addition to the freight already paid, and the freight already paid shall not be deducted, but either include letter, I mean, it's not a notification, it's a letter issued to all the. Here, what is sought to be done is, 4 times is all right, but on the entire. Now, from where this power has come, that is this, and if it is, it would have been an amendment of the rules, I can understand. But definitely there appears to be some.
Another thing, Mr. Devsuri, very relevant. Rule 126(1)(a) or 1B stipulates about a consignment. However, this 2.6 says about the container.
Yes. In any container.
So can we ascribe the same meaning from the consignment to a container?
Your worship, raise the CPO. Container trade operator. CPO is the container train operator for purposes. These operators, they book the entire
Hmm.
thing. The entire rate. And so we have to read it that way. If there is a misdeclaration, in case misdeclaration is detected in any container, always charge on the entire rate, because what happens first, they book the entire rate. That is the container train operator, and it's the consignor who books here. Now, so far as lordship, this rate is concerned, lordship. If your lordship will see
Rate will mean the entire.
the entire. If your lordship,
Whereas, because 74 will only come in if it is a consignment. To put the burden on the consignee if it is only a consignment.
that is what I am trying to. If I may take the lordship. Page. Starts at page 9.
Yes.
I'm just reading from that. We have conduct physical verification on the containers.
Hmm.
Containers. Arrived from so and so in front of the authorized agent of the party. And our security personnel went and found that 63 years were stuck with billets and ingot, which comes under notified commodity. And rest 17 was sponged. And among this, 63 years, 32 people were declared as ingots and billets, and rest were declared as sponge. So there was a misdeclaration.
Hmm.
Of the 63, 30 were declared as ingot and billets, and the rest were declared as sponge, but commodity is found billets and ingots. Now let's see the next discussion. It has been marked worship. This is worship has got it. It is not a case that the consignment to Lavisi steel is not related.
Hmm?
I'm sorry, it's not a case that the consignment to Lavisi steel is sponge. It is related in those, there is no discrepancy on that. Therefore, lordship, if we construe it as consignment, I do not find any.
far as the consignee is concerned. Correct, this one.
So the imposition upon the consignment would not happen.
So, if we look at it as a consignment, my reading in Washington has to be read as a consignment because, suppose let us take this right. Where are the things going? Washington, see, Tripura stocks, that would be one consignment. Nadi Steel, New Delhi Steels, Sri Krishna, Shillong is one. So there are so many consignments. It might be the same ones.
These are all consignees
These are all consignees, Washington.
and the consignors are on the right hand.
These are consignees and the consignments are meant for that. So the consignment is for these particular consignees. It has to be read as a different consignment. Their quantity may be different. But so far as this consignment, so far as at least as it is Washington, it is admitted by them. That there is some misdeclaration in some other consignment. But taking plus 2.6 as a ground,
They are doing it for everyone.
perhaps that is,
So then we may not interfere, we have to interfere with the guidelines,
guidelines, Lordship, this
2.6
2.6, that's
being
what-
contrary to 126.
Lordship, because 126 comes from the rules. It's from the rules.
And these are only guidelines.
These are only guidelines.
So the imposition on the basis of 2.6,
That may not be.
you have filed your affidavit.
No, Lordship. This Lordship is additional.
You file your affidavit to the additional, because that is required. Because this adjudication will affect the Odisha.
Yes, yes. Odisha, I don't know how
Now,
that-
the Odisha matter is there. Odisha matter, they have challenged it. See. Huh?
It's not further affected. That is right. I don't know how that works.
Because today you are saying this on an interpretation, on the face of it, it transpires. That is why I asked them to file the affidavit. When did they file the affidavit?
They are filed. That is on the 8th of 18th of this 18th of September. Yes,
Then
sir.
why haven't you filed the respondents, including the railways, are directed to file their replies by 310?
That is a con-
Why haven't you filed? I asked them therefore to file it on 2910.
Earlier also in this case, last my senior was, she had made a, prayer for nation. 1 year I tried it, more than 1 year I tried. It's not this-
Huh?
it's not this-
No, let them show what is the power. Because these guidelines has to be,
It has to flow from some source.
some power has to be there.
It has to flow from-
And these are mere guidelines. The guidelines cannot overreach the rules or any other thing. What do you say? I can close it out. But at the end of the day, you may be a difficulty if I take your submission.
I see from the.
Now, that is what I felt on that day occasion. That is why I asked her to bring on record these documents were not there. They had given it on across the year, but
It's only nowadays from the internet we can download the whole property. She will give me one opportunity if it comes. But on the face of it, I think. Usually, this is. Yeah.
well, I have already given you how many, 13 days.
No, no, I was finished before Puja. I'm quite tired.
Let's have it on 17th. 17th. Huh?
It is not in the guidance system of
16th is Monday.
and the 19th of
19th is,
the last.
I'm sitting only half. If you want to have it before, but let him, would it be possible? Let's take it on 19th, 17th. You are not there,
I'm not there for
17th? Okay, don't worry, you have been heard everything. Only him. I am only to pass the judgment out. She'll be there, no problem. There's nothing else. Unless they come up with some power. If there's a power, I will accommodate it. If there is a power, if they so. Otherwise. Pursuant to the order dated 12/9/2023, an additional affidavit has been filed by the petitioner on 18/9/2023. This court had permitted both the respondents, including the railways, to file their replies to such additional affidavit by 3/10/2023. However, no such affidavit has been filed. Mr. R.K. Dev Chaudhary, the learned Deputy Solicitor General of India, appearing on behalf of the railways, seeks for a short accommodation in respect to the to file the accommodation to obtain necessary instructions and to file their reply. Taking into account that the instant proceedings have been pending from the year 2015, this court fixes the matter again on 17th of October. The said additional and the said reply be filed by the respondents without fail by 16th of October. It is made clear that if no affidavit is filed, this court shall proceed to adjudicate the matter on the basis of the materials available. This is the matter for further consideration on, this is the matter at the top of the list on 17th.
Number 3, permission.
For exemption?
Yes.
Delay?
According to my law, there's no delay.
Where is Mr. B. Chaudhary? That day he produced something with a signature A. That is it. Where is the impugn order? No, they say that they have not given you. Why? Pay for refund. You have asked for payment. The claim for refund in view of your eligibility. And that has not been granted, and for which you have come, they have taken the point that you have not done it within 6 months. 6 months as per that particular clause. Where is the clause? Where is that eligibility? Where is that certificate? Notification? No, there is a time limit given. There is a time limit. Refund of tax during the period of the application. This is for the period during when you file the application. This particular. And you are to file at There's a time limit, notwithstanding anything contained that such application has been pending for disposal, the amount of tax without claiming it shall be paid to the demand. Can claim refund of the taxes paid in excess of actual under after receipt of demand. The said application of refund so and so within 180 days from the date of receipt of the certificate of entitlement. Okay, so certificate of entitlement, when you got it, you immediately file it. And they say that you have received it earlier. Who received it, they don't know. Authorized representative. And the signature is A. I remember this. So, I think anything else? Okay, we dispose it off. Now, the instant repetition has been filed by the petitioner, seeking a direction upon the respondent authorities to make payment of an amount of rupees 3,97,159 with further interest from the date of filing of the instant petition. The case of the petitioner herein is that the petitioner being eligible under the industrial policy of 2008 had applied for an eligibility certificate by filing an application on 31/12/2010. The eligibility which the incentive for which the petitioner filed the application for grant of eligibility certificate was for claiming exemption of tax under the Assam Industries bracket tax exemption bracket close scheme 2009. The petitioner was granted the eligibility certificate by the General Manager, District Industries and Commerce Center, Nagaon, bearing number DICCN bracket US bracket close ST oblique EC oblique 287 oblique 2011 -12 oblique 2258 -2260 dated 27/5/2014, which was signed on 2/6/2014 in respect of its finished products, that is MS nuts and bolts. The said eligibility certificate has been enclosed as Annexure A to the writ petition. And it appears therefrom that the incentives which have been approved were VAT exemption for a period of 7 years with effect from 14/12/2010 to 13/12/2017 with a ceiling of maximum 200% of the fixed capital investment of rupees 22,76,900, that is rupees 45,53,800, semicolon. Power subsidy subject to a ceiling of rupees 10 lakhs per year, with effect from 14/12/2010 to 13/12/2015, and drawal of power line that is rupees 2,26,154, subject to a maximum ceiling of rupees 10 lakhs. On the basis of the eligibility certificate issued by the General Manager in District Industries and Commerce Center, Nagaon, the respondent number 3 had granted the certificate of entitlement number C01N WG/1S/IS/02269 dated 26/4/2014. And it has been categorically mentioned in the writ petition that only in the first week of the month of October 2014, the same was made available to the petitioner. The said eligibility certificate of entitlement have been enclosed as Annexure B to the writ petition, and it reveals that the certificate was valid from 14/12/2010 to 13/12/2017, subject to renewal from year to year, and the exemption the incentive which was granted was exemption of tax to the extent of rupees 45,53,800 within the period from 14/12/2010 to 13/12/2017 in respect of the sale of the finished products, namely MS, nuts and bolts. It is the specific case of the petitioner that from 14/12/2010 till the grant of eligibility certificate by the respondent number 3, the petitioner paid a total tax of rupees 3,11,859. After the grant of this certificate of entitlement, the petitioner claimed the refund of rupees 7,973 for the period 2010-11, rupees 1,27,283 for the period 2011-12, rupees 1,16,805 for the period 2012-13, and rupees 59,798 for the period 2013-14, totaling to rupees 3,11,859 by filing applications for refund as prescribed under the Assam Industries tax exemption scheme 2009. The same application was filed on 7/1/2015 as per the petition. No. It has been specifically also mentioned in the writ petition that as the applications were filed on 7/1/2015, that is within the prescribed period of 180 days from the date of receipt of the certificate of entitlement, the same application was on time. Mr. What are you mentioning here? At paragraph number 6, you say something which is contrary to which is there in paragraph number 3. You say the aforesaid certificate of entitlement, though shows the dated 24 year, but the same was signed by the authority respondent on 24/9/2014, and the same was made available to the petitioner in the first week of the month of December 2014. On the other hand, here you say at paragraph number 3 that was granted the certificate of and signed by respondent on Iman, and thereafter by the first week of month of October 2014, you got it. Why it is contradictory?
According to the certificate, according to my of the bank,
No, the certificate of entitlement clearly shows it to be on 6. Why you are saying about 9? Huh?
signed by the authority.
Where?
B and B by the.
Yes, where is it? Where are you getting 9?
24/9,
Where?
Roman 9. 24/9.
Too much. Let us not go into those intricate details. The petitioner, after submitting his claim of the amount of fees, 3,11,859, have been pursuing with the respondent authorities for payment of, for reimbursement or refund of the same amount. And in that regard, have issued various communications to the respondent number 3. As the same amount was not paid, the petitioner has approached this court by filing the instant writ petition. It reveals from the records that this court, by an order dated 4/3/2020, issued notice the record further shows that an affidavit in opposition was filed by the Commissioner of Taxes on 21/8/2023. In the same affidavit in opposition, it was mentioned that a certificate of entitlement was issued after observing the due procedure on 24/6/2014 and was delivered to the authorized representative of the dealer on 24/6/2014 under acquiescence. It was further mentioned that as the petitioner, authorized representative of the petitioner, received the certificate of entitlement on 24/6/2014 and the application for refund was filed on 7/1/2015. It was a delayed application. And under the provisions of para 9(2) of the Assam Industrial (Tax Exemption Scheme 2009), the petitioner is not entitled to the said amount so claimed on 7/1/2015. To the said affidavit in opposition, a reply was filed on 14/9/2023 by the petitioner, stating inter alia, denying that the certificate of entitlement was delivered to the authorized representative on 24/6/2014. It was further mentioned that there was no document shown to the effect that the certificate of entitlement was handed over on 24/6/2014 itself. Pursuant, the instant writ petition thereupon came up before this court on 15/9/2023. Taking into consideration the stand which have been taken by the Commissioner of Taxes in his affidavit, that the certificate of entitlement was handed over to an authorized representative of the petitioner on 24/6/2014, and the specific denial of the petitioner in the affidavit in reply to that effect, and denial of the petitioner, specific denial of the petitioner to the said statement of the Commissioner of Taxes. This court, by the order dated 15/9/2023, directed the Standing Counsel for the Finance and Taxation Department of the Government of Assam to produce the certificate of entitlement dated 24/6/2014. No, to produce the records which shows that the certificate of entitlement dated 24/6/2014 was handed over to the authorized representative of the petitioner. This court accordingly fixed the matter on 27/9/2023. On the same date, Mr. B. Chaudhary, the learned Standing Counsel for the Finance and Taxation Department of the Government of Assam, have produced the no. Have produced the records as well as the, what is that, the peon book?
No, it's the proceeding process. It's a
Process server.
file. Process file.
As well as the process file. No, You are referring to this A.
Yes.
Where is the seal? Where is the date? Upon perusal of the process file pertaining to the petitioner, there is no mention as to when the said certificate of entitlement was served upon the authorized representative of the petitioner, save and except an acknowledgement number NWG 3984-144 dated 24/6/2014 have been mentioned. From the records, nothing could be shown, seen, as well as being shown, and as well as was shown that there was any signature of an authorized representative of the petitioner. From the records, there is nothing could be seen. From the records, it also does not transpire that the said certificate of entitlement was received by any of the partners of the petitioner or by any person authorized by the petitioner firm, by the petitioner firm to receive the certificate of entitlement. Though Mr. B. Chaudhary, the learned standing counsel for the Finance and Taxation Department, during the course of the hearing, referred to an initial to be the authorized, to be that of the authorized representative of the petitioner. But it was not, but the said initial, but from the said initial, it cannot be known as to whether the person concerned was the authorized signatory, authorized representative of the petitioner? Apart from that, the said initial, even assumed for argument's sake, to be the authorized, or it would be to be of the authorized representative of the petitioner, does not bear the date. Under such circumstances, the reason for denial, the entitlement of the petitioner on the ground that the certificate of entitlement of the petitioner was served to the authorized representative on 24/6/2014 is not at all tenable. It further appears from para 9(2) of the Assam Industries Tax Exemption Scheme 2009. That a claim of application for refund has to be filed has to be made in format in Annexure Roman 12 within 180 days from the date of receipt of the certificate of entitlement. As the certificate of entitlement has been issued by the respondent number 3, the burden therefore lies upon the respondent number 3 to show that the certificate of entitlement was served upon the petitioner or upon the petitioner in the instant case within on 24/6/2014. As above mentioned, the respondent authorities completely failed to discharge their burden. Under such circumstances, it is the opinion of this court that the petitioner, having filed the application on 17/1/2015, would be entitled to the amount so claimed subject to the necessary verifications as per the scheme of 2009. Accordingly, this court therefore disposes of the instant petition, directing the respondent number 3 to verify the claim of the petitioner as submitted on 17/1/2005 for the periods 2010-11, 2011-12, and 2012-13, and 2013-14, within a period of 30 days from the date of the issuance of the certified copy, submission of the within 30 days from the receipt of the certified copy of the order, of the instant order, and thereupon disperse the said amount within 15 days thereafter. The petitioner The respondent number 3 shall also consider, shall also take note of where interest provision
Section 52 by the, Assam.
on refund. Refund also.
Right.
52. No, how are you claiming refund on the interest here? Where's the interest? Huh? 52 or 52. The register is entitled to refund in pursuance to any order under this scheme, including assessment or in pursuance to any order by the court, shall be entitled to receive the same. The respondent number 3 shall also duly take note of Section 52 of the Assam Value Added Tax 2003 on the question of the entitlement of the petitioner to the interest while carrying out the state verification. The record so produced is returned to the record so produced by Mr. B. Chaudhary, SC, Finance and Taxation is returned.
Number 21.
Ah, ah. What is your case? Let us see.
Impune order is a pay for 30 months. Yes, that is.
Hmm. With reference to the cited above, I am directed to inform you that the land measuring 480 hectares in 7 patches as shown below, which is identified by the Forest Department, is hereby allotted to you for compensatory afforestation in the
I'm concerned with serial number 3. Lobby, Dawla Buko, US under Assam Rate.
Hmm,
Total area is 86.2 hectares.
hmm.
This is a village mother. Where it's not a residing mother.
What is USF? Unreserved? Then.
Total mother, 480 acres of land will acquired. Out of which mother, from our village over 86.2 the property to be acquired.
Hmm.
So they find this restriction challenging this acquisition matter and give a status order. Now they have filed an affidavit that they are going to sitting this village matter.
Huh?
They are going to sitting this proposal matter. And because our village is concerned, they are proposing for another site.
Where?
In the affidavit, it's number 39, is 41.
Upon the petitioners will agree by the decision of area for shifting under demand for efforts in connection with so and for which they have approached this person. From the letter issued by initial February, the clearly reflected in connection with implementation in the different location which will be identified shown from the What is this letter? With reference to,
This for in the application level, running it 41.
with reference to the cited upon I am to request you to seek the gaps of land. Then
Now they are going to choose a different place in lieu of our place.
this is what has been given. Now have they done it?
The spot has not been.
No. Is it their specific case that they are not going to touch your land?
By this, Alexa 40, is 41 my lord. It is now they are going to the different route.
But why they have not made a very specific statement to that effect? What have they stated in paragraph 6? You read it?
This one, I am directly request you to seek the.
No, paragraph 6, what do they say? Let them come up and say that yes, because they are this was issued by the Secretary of Revenue. Let them come up with a specific standing. Yes, they are not going to disturb you. That ends. Why this is not being given? He is only asking somebody to look for another place. And I did say, but does he have the power to do that?
Here,
Because he has not modified this order. Has he modified 1/6/2019? Tell me.
that
If he has not done today, if he has done it, if you say it's a case of withdrawal, it has become infructuous. And if he has not done it, then he has to do, or we have to decide. But can I, on the basis of their affidavit, at paragraph 6, where they are not clear,
but they are relying on a document where it has been mentioned that they are.
let them read paragraph 6, read it.
That the document they should take the-
I have no problem in saying so, but tomorrow you will be in trouble.
Yes, ma'am.
I will only say that taking into account the stand of the respondents now, nothing survives in the repetition. But would that suffice you?
No, madam, because
Because
this once.
this is not clear.
Let them-
They are to amend. If this is so, they are to amend that order and say that this is outside.
That has not been done.
Then, and this is being done by some additional secretary. Then he will say the revenue secretary the revenue secretary never did it. See?
If there is no secretary review, madam.
Earlier it was done by the revenue secretary. Then the pointing finger, putting blame, then you are nowhere. Ain't it, Mr. Sharma? Or you give another, you say that you are not going to do. I'm going to say that and put it that this means this.
I had a talk with this secretary.
See, Mr. Katunia, see,
Otherwise, the intention is to.
all of you want to put the blame on this court. That this court should, on the assumption of that, say that this. Why will this court sue? Either they have to come up with a better stand or clarify it properly.
Let them claim it, otherwise, madam, there is
Level.
no way.
The instant petition has been filed by the petitioner, challenging a communication issued by the Secretary Revenue, NC Hills Autonomous Council Haflong, whereby 480 hectares of land in 7 patches, including a patch of land measuring 86.23 hectares at Nabdi Dolabuku UCF under Haflong Range, was identified by the Forest Department to be allotted for compensatory afforestation in the Dimahaso district. Pursuant thereto, pursuant to the filing of the writ petition, there was a stay
That's all.
to the said communication. Only to the effect of this or all?
Only the effect of this.
Only. Lead communication. Only. In respect to Nabdi, Dalagopu, USF, and the half long range. It reveals from an affidavit in opposition filed by the respondent number 5, who is the Secretary, Revenue, North Kachar Hills, stating inter alia that from a letter issued by the Additional Secretary, Revenue, to the Chief Conservator of Forest, Dimahasau, dated 11/9/2023, it clearly reflects that, in inverted comma, in connection with the implementation of 120 megawatt Lower Popili hydroelectric project at Longpu to a different location, which will be identified shortly in Dimahasau due to some unavoidable circumstances, inverted comma. It is not clear from the said affidavit as to whether it is the stand of the respondent number 5 that they would not proceed with the compensatory afforestation in Nabdi Dalagupu village at measuring 86.23 hectares, thereby amending the proposal sent on 1/6/2019. Accordingly, this court directs the respondent number 5 to clarify their stand clarify the stand by filing an additional affidavit. List the matter on how long, Mr. Sharma? List the matter on 20/11/2023. The affidavit be filed by 17/11/2023.
The directed the developers of
Hmm.
clarifying this 10 laws. And the copies of this has are also laws. The finally
File the affidavit.
So filed on 9.
Hmm.
Last 29.
I don't have it.
If it is not in the record, or if I can show it one copy.
Hmm.
Sorry, not like I mentioned in the morning or the product from my. Before the part. From paragraph 3 law, from paragraph 2 lordship, from the direction from by your lordship, from paragraph.
is an online copy of the letter.
Yes, Mr. Sattar, what do you say?
The letter deputy commissioner has filed two applications. Now both are contradictory to each other. Now, my lord, before I should place any other thing from the activity, I would request our people to kindly peruse page number 31 of the application, my lord. Where from I have been and with the being class. Page number 21 and accept B, my lord. Of Great Commission 2639.
Two, 236, 2639. Yes,
That is the notice, my lord. For some of
page 20.
21.
Okay. Page 21.
This is-
Yes, Kotian.
Yes, this is a copy of that. my lord.
Hmm.
That is section 18. My lord, my father's name was Biren.
No. This is a certified copy of a Kotian. Page 21, Annexure B.
Yes, my lord. Yes. So, my lord, this Khatiyar was issued in respect of, my lord, item number 730, 574, my lord.
Hmm.
In respect of 5 we have left over so and so, and then Woodbury 771, 771.
Let's see the here. 574 and 771.
Yes, my lord.
Purana 730. And then it became 574 and 771 oblique. Okay, then
My lord, 730 million. My lord, then page number 31, my lord.
yes,
But this is the notice and the making. Here, my lord, in the schedule portion, you will also be pleased to see that number 701, 704, probably 1105, and 1688.
Hmm.
In the start of it, the letter that the commissioner has filed into activities, and those are for that. Because this is the place from where my lord I. This is the government land from where you are having. So you are the royalty of that land, lordship.
that I understood.
Lordship.
Here, let me hear you. What does it say? Yes,
Now, my lord, here, my lord, if this dar is contained as dar number 704, and in respect of which, my lord, page number 21 refers to, then
page number 21 doesn't refer to 704.
yes.
It does not. It does.
70.
it doesn't refer to, page number 21 does not refer to 704. It refers to 730, 574, oblique 771.
Yes, so that number, this 574 is created out of that.
How do you say?
Well, that is what the Deputy Commissioner in the earlier.
That is what he didn't understand. That is what I'm saying. Your patta, you if you have got a khotian, the khotian has to be under a landlord.
Yes, sir.
It can't be the government.
No, man.
If it is under the landlord, then the patta must have been issued.
My lord.
And the patta in that case was 135.
Yes.
And in that case, in that patta, which has now become a different number, something different has, it is seen from here. Here. 730, yes, 730 oblique 574 oblique 771. That happens to be the patta number of something.
605, new, and that number 176.
No. Now patta number is 135. Yes, 135.
That was the earlier.
That is the 135. So you were right under Hosnur Ali and Sukhona Sheikh.
Yes.
So in their names, the land is still there.
My lord, that's what they say now, but no copy of that has been furnished to us, so as to be aware about that new patta and new dam. Along with this, my lord, though it is said that copy is an act, but to me, my lord, nothing is given like.
Understood. Mr. Sarkar, these things can be, these are very trivial things. But the question is, what the Deputy Commissioner has done earlier on that letter, he has made it wrong because he couldn't have. That is why my specific question on the last occasion was, it could not have been. A patta could not have been issued. Where are my orders? Here. Here, you see, during the course of hearing, the Arbodaya Learned Council has instructions issued so and so Iman. This court finds it relevant to observe that the issue involved in the instance is as to whether the land covered by dark number 771 old 730 new of KP Patta number 135 under Jalukbari is included in the land covered by dark number 704 old 168 new of Posim Boragaon under Jalukbari Moja. From the draft sheet which is produced, it is seen that on the basis of an order dated so-and-so, a plot of land measuring 5 bighas, 2 kathas, 7 lechas from dark number 771 was settled in favor of Khajnur and Sulokha Sheikh. If the said land has been settled, the same could not have been a part of the government land. Under such circumstances, this court directs the Deputy as well as the Commissioner to file an affidavit in terms with the earlier order as well as the instance clarifying their stand. Now they say in their affidavit that that land still remains. If you see the affidavit which they have filed today, where is that? Yes. Kindly come to para 3, the last portion. After completion of the settlement operation, dark number 1763 new and Miadi Patta 605 have been created from dark number 730 old and Miadi Patta number 135 of revenue village under Jalukbari Moja. As per the record, the said dark number 73.29 R, which is 5 bighas presently Mohammed so-and-so, both are sons of Khasur Ali Sayara Khatun, wife of and others are the recorded pattadas of there. During field verification, it was found that the petitioner was occupying some other land. Now, interestingly, another aspect which you may find it here, as I could see from him, is in this document also, Well, look at this document. There your father's name has been mentioned as being in occupation for the last 20 years. This must have been found during field verification because this is inserted at the time of field verification out there as a Dakhal card. Although in the land revenue regulations, you do not find the concept of Dakhal card, but you find it out there, I think in Rule 72 or something. It has been mentioned that the concept of Dakhal card is there. I came to know about this thing, Mr. Sattar. You remember that case both of us were doing, Mumin Ali. So there in that case, I was searching, where do you have this word called Dakhal card? Because the land revenue regulation is completely silent. You have the proprietor, landholder, settlement holder. These are there. But where do you get the Dakhal card concept? The Dakhal card concept is there when you make the field verification.
And here the also that you pointed out, first. Not yes, first about margins of what. And the same thing, my lord, is reflected here at page number 21 also. That is my third.
This is the land.
Yes, so this is 771.
This is 771, which is Dagna pertaining to Patta number 135.
Yes, my lord. My lord, here, my lord, there is nothing, only that number is mentioned.
No, Patta number is there. See? There will be some Patta number there. It is there. It is some,
Yes, 135.
yeah, it is there. Now, another thing, apart from that, this land, where the government land is also there. No, that is another land. This is the Patta land. Here another aspect, see this. See, this is another document which is relevant, wherein your father's name also appears being in possession for 20 years in this government land. Here you don't have a Patta number. It's a government.
Yes, and the Raja Bhau Sarkar, yes,
And on the right, extreme left, yeah,
20 years.
20 years.
Yes,
And down below there is a Montague, see,
yes, madam. Also, that Asim, the grazing reserve, grazing reserve.
then down below there is also some Dakhal, ASO field verification. And this is the present one for the government land. You gave me 3 copies, no? Oh, another one. Another. What is this?
This is the new one. Regarding their crop of the Manipatala.
Ah. Here there is no name of these people.
Yeah.
What about the Khotian? You see this, you may have to challenge this aspect, maybe in some other proceedings. This is the new one, you see, of that Dag, where your name was there for 20 years. Which earlier belonged to this Khosnur Sheikh and all. This is the land, which have been given a different Dag now.
And the Patta which is shown here, my 605.
That is why it has now become 605. From 135.
Where it has become 605?
From 135, that is what they are saying.
My lord, there is nothing mentioned like that.
No, that is not mentioned here, which ought to have been mentioned.
Yes, sir.
But as from the affidavit, it appears that that 135 has now become 605.
My lord, we have a proof that 132 has only become 605.
135.
Yes. 132 has become 132 has become 605. We knew that something may happen like that. That's why, my lord, we have. And when the deputy commissioner, my lord, is having all the records with him, and the circular officer is also in his company, then where from that number, this particular number 605 has come, at least in the settlement operation. Now, I was a witness in the year 2014, my Katyan is of the year 1978. So at least they ought to have mentioned where from this new Patta 605 has, whether it is from 135 or whether it is from any other.
Then they should have mentioned that.
Other 605, but it is from factor number 1.
Show me that. Though.
No, my lord, this is and the thing. So lordship is just automatically now the records are not available. Have any copy. Lordship, this is the.
But this is my document which I gave it to you.
And moreover, my lord, after 9 months of. Moreover, my lord, after 1964, there is the Monja separation. Only by this time the settlement operation has been carried. But that also the deputy commissioner has failed to mention. What was the duration of that settlement operation?
Did you file your application for ownership?
Yes, sir.
What happened to that?
My lord, in the earlier, I mean, the deputy commissioner has already written a letter that he has already filed the application, and this is my lord, the secretary had page number.
No, it's okay, but what happened to that?
That is
Means your father's application.
still pending.
So you have not been given the ownership right. So 21 10, because what has happened in the meantime is this. That is not there, but this is a Jamabandi copy, a Sita copy. This Sita copy shows that a lot of other people have gone inside that land. So now you say that 605 has come from some other land. Patta?
Definitely, my lord, because it was the duty of the deputy
No,
commissioner.
it's okay, that is another thing. I'm asking you whether as per your information and materials available, does 605
Has
come from 135 or any other?
132.
You file a reply to that.
Yes. Let me give a copy my word of this. The chitta which is annexed.
No, I have not annexed it, I just claimed leave. We can work with the letter I can. Can put it in the model.
But in this chitta, there are 3 to 4 chittas. But these chittas do not show that about any riot.
Those chitta. Yes, but Katyan is issued by the institution. The full and sole authority functions of the life.
Now, that is okay, but what has happened thereafter? Why that application has nothing has happened?
Yes, for that, my lord, there is already a letter.
That letter of 6-2. 6-2 is useless. I mean, the deputy commissioner wrote it without knowing anything. Yes.
On that day also, the worship at least to show the anxiousness about that letter.
I made it clear. Now he has said what to do. And what about the trace map?
Yes, Lord.
Show me the trace map for these 2 lands.
But I have received 2 different, not joint figure.
Obviously, it can't be same. Maybe if it is somewhere else, because here we are having 802 Rs, which will be a huge plot of land. This is 8. It will be 1265. Yeah, 1760. Now, this case is a case where you have been evicted. You say that should be the patta land. From the patta land. They are saying, no, this is a government land. How can this court decide now? Tell me.
Now they are saying that it is government land.
They have been all along saying that it is a government land. That is why the notice was issued to you at best. Didn't it? They issued the notice, which you have shown me at page 35.
Yes. But my lord, the Katyan which I have obtained from, under the Kashmir and Sons. That person, my lord, I have already given.
This page number 31.
So that is it. They have been all along saying that you do not, you are in government land, 70411051688.
Yeah, see, like that, my God, but I have been evicted from my Katyani. From my Katyani,
How can this court decide?
I will tell them. And that would regarding the conversion of Katyani to 6 so I.
No, if that land is now government land, which they show it in the map out here as 1680, from there they have evicted.
And my lord, the Katyani which was given to me.
That is in respect to this another land which is nearby to these places. See this trace map. It is abutting some road with 9 having the boundaries of different, which has nothing to touch with your land. 1763 is a different plot of land. You were in occupation. There's no quarrel that you were in occupation of the government land.
No, I was not the of the government land. I
No,
was
but
not-
that has been recorded in the Khotian, the Chita, which is they have produced that you are in occupation.
In the Katyani, it is not recorded that I am in the government land, but.
No, no, not in the, you may be there in the Khatian. I'm not concerned with that private land. But in that 1680, the Chita clearly shows that you are in occupation of having 20 years of occupation in government land.
Looking at a opportunity. Kindly, and direct them to give me a copy of that.
Which one?
Chipta.
Chita, you take the photocopy, this one? You have a photocopy of this? You want only this one?
No, there are 4. But there are 2 kind of.
But earlier too.
In the earlier, I mean, along with the earlier, my lord, they have shown to have something. And today also, my lord.
No, these are the 4 only.
Oh, is that,
There's no new
I
thing.
have not direct or should I crave it?
There's no, because how can you enclose out here? No, but this, I think this is for this 1763, this is the document. Chita. And the government land which is there, it has been shown that you are in possession of 20 years in the government land. Yes, what do you have to say?
But I find there is my different kind of my product. It is an interest of the business. We are going to we can do product occupation as a product buyer. Prior to that, there was no land. It might quite so open my love. These 2 lands, sort of lands are on a contiguous to each other.
There is no contiguous. That is what I'm saying. See these two. It's not contiguous.
Now,
See the boundary of 1763. 1763, which is the land now which has been shown, has nowhere any boundary one with 1688. So how do you say it to be contiguous? But can this court decide all these things? I have taken the interest on the matter only because of the deputy commissioner doesn't writing letters out there without knowing what is it.
Also, who had been in occupation of this particular land,
Huh.
it might quite so happen, madam, that they came into occupation of a government land. So, because of the simple fact that it is the offender, is the own, those persons, landowner, who will have to induct them and try. It might quite so happen, the offender, in these persons might have taken the citizens, the predecessor in interest of the petitioner, Brian was, I said, look, this is the problem that you can have. Because government gave is nobody said for where fire protected. It is US that it must be like. So they came into occupation, they continue. But on the accounts, my lord, this is somewhat different.
No, that is why if you, if you see these cheetahs, here cheetah, no particular, no, why I am saying is here, this cheetah, see this one, see the remark column out here, who is in occupation? See the name, what is the name?
So there was a GM who had to follow. Of course, the Korean, of course,
No, where? That is which is that?
there are that is pertaining to the number 730.
That is Biren Borgohain mentioned on the right hand side? No, on top.
Okay, of course, the Borgohain Peter, so it's a couple
So he, therefore, from there also it shows that Biren Borgohain, the father of the petitioner, was in occupation from that field verification. And here also, in this land, he has been shown to be in occupation. Maybe.
Now we cannot table these documents, these are comfortable. And Lordship will tell me, say, 708, this is that, here, my lord, Patada, Nam Soba, it is government.
That I also know. No, I am not on that. This shows, therefore, that he is in occupation of two lands.
Yes, sir. Yeah.
But he says, now what has happened, that particular plot of land, which has now become 1763, there is nothing or no presence of him has been mentioned in the Chita. Why? When he was the righty. See this. No, see this. Why this is so empty? This is what has become. Now, as per the affidavit, 135 has become 605. Okay, 135 has become 605. Now, it is the stand of the state which they are going to file it, that 605 comes from 132.
Yes, sir. From these records, it is not there, but they are saying that.
Because what happens, no, where is the Purana Das? Why there is no Purana Patta number? Tell me.
Yes, it is only mentioned at 605. Only the dark is mentioned when it's 7 right and only 1760 not true. And so far the Bhakta is concerned 605.
Why? Why there is no mention? Does the righty, if a person has been issued a Khotiyan, the Khotiyan loses its existence by a flux of time. So why it is not mentioned if there is a righty, unless the right has been cancelled? So it seems that the cheetahs are not so complete. They must have done in a haste in view of Mr. H. Sharma must be asking them a lot.
Immediately matter the authorities there in a position matter they not comprehended that thing. They knew that thing was not therefore matter.
Anyways,
So logically so direction matter to bring on record of the materials matter.
no, now they have brought in these cheetahs. You produce it on the next occasion. Mr. H. Sharma, the learned counsel, as well as appearing on behalf of the Deputy Commissioner, Kamrup Metro, submits that the affidavit pursuant to the order passed by this court on 19/9/2023 have been duly filed by the Deputy Commissioner, Kamrup Metropolitan. So the copies of the chitas pertaining to the various darks have also been produced along with along with the trace map of the government land as well as the land belonging to, as well as the land in dark number 1763 of Patta number 605. The said affidavit filed by the respondent number 2, however, is not on record. The registry shall bring on record the said affidavit. Mr. A. Sattar, appearing on behalf of the petitioner, submits that he would like to take some time. He would seek for an accommodation for filing a reply to the said affidavit filed by the respondent number 2. How much after vacation? Taking into account the above, this the matter again on 23rd of November 2023. The affidavit in reply be filed by 21st of November 2023. The chitas which have been produced along with the trace map be produced on the next date also by Mr. H. Yes, Mr. Goenga, your matter.
Into 19.
So what is there? You don't have.
Record is not there, some blue sheet was provided to me. If not, say allow me, I can file an affidavit.
Mr. Goenka, what he submits is on the first point. That in the documents which you have disclosed during the in their income tax, wherein you have shown the purchase price is 0. And on the basis of that, you have claimed the profits. Whereas from other documents, it revealed that there was a purchase price of the shares, and accordingly, this was the profit would be less if we take into account the purchase price of the shares. That is on the merits. Now, on the question of jurisdiction as to whether it should have been done under 151, 151B, he says that it has been done by taking into account the approval of the Joint Commissioner, for which this court directed him to produce the records. Now, as of now, he has not been able to trace out those records. So he wants to file an affidavit. That is what he says.
In all the four cases, it's very clear from notice under section one.
No, they say that the notice cannot be changed because it is on a particular template. So that is what their stand is, that yes, we have, but the question is whether we have taken the approval from the Joint Commissioner. If it is there on records, it is there. A notice, if it is not mentioned, would it become bad on that basis? If they have taken the permission from the Joint Commissioner?
I just say before the notice under section 1.
I've read it. Is it going on?
The notice says, after obtaining necessary satisfaction of the Commissioner of Income Tax.
Understood.
in
So
all the
they
cases-
say that it is typewritten. They can't change it. So they have used it like this, the notice. But the fact is, in records, they have it. That is what they say. Would the 148 proceedings on the basis of the language of the notice be bad? If it is available in the records that they have taken the approval from the Joint Commissioner.
No, I will explain the first question which you also have asked of the zero force question. First, I will mention my role. Now, it is a settled law, my lord. If there is a challenge to notice under section 148, then the reasons which have been recorded have to be read as such. There cannot be any deletion, alteration, addition, subtraction. So, what has been recorded? Now, from the regions as well as the notice, it's very clear that the notice has been issued with a prior approval of the Commissioner of Income Tax, all the four cases. Now, there cannot be any substitution, deletion, addition. Number one. Number two, my lord, it has also been held that whatever they want to disclose, they have to disclose in the regions recorded or the notice issued. They cannot withhold something and they cannot produce something at the time of hearing by filing affidavit or by producing additional documents. They cannot keep something under their seat and produce it later on. The entire validity of the notice has to be judged on the basis of reasons recorded and the notice issued. This is my submission.
No, Mr. Goenka, there's no quarrel with that proposition.
Yes,
The first of all is there has to be reasons recorded to their satisfaction.
Yeah.
Now that reasons you can't supplement it now.
now,
There's no quarrel with that proposition. That I think Mr. Kyle also is well versed in that law, to the effect that the reasons can't change with the timing. But whether there were the reasons recorded at that point of time is the question. That is what. Now the second is whether mentioning out there in the notice that the approval of the commissioner has been taken, whereas the approval of the Joint Commissioner was taken, could vitiate the entire proceedings. Yes. I don't think so. That cannot be. But if it is, I have a difficulty, but there is a coordinate bench judgment for which I have. When you are, or you have already taken the permission from the higher authority. What is the higher authority? The reason under 151(1) is why is it required 151 from the commissioner if it is more than 5 years? If it is less than 5 years, you have to take it from the Joint Commissioner, meaning thereby that if it is a less within a smaller period of time, then you can take it from the subordinate officer. But if it is more than 5 years, you have to take. But if it is taken from the higher authority, what is wrong? But anyway, there is a coordinate bench judgment. I would not like to go into that. But I think what about the records? You don't have the records. Understood? But whenever, isn't it the law also? When a proceedings under 148 is challenged, You know that this has been challenged in 2016. You are to produce the records.
Only whatever.
No, but unless you produce the records, can it be decided? Isn't it the law? That when there is a challenge to 148 proceedings, the records have to be looked. Unless it is a case that there is no case made out at all. Isn't it, Mr. Goyal? Because without the, if you don't have the records, means something is wrong. But they knew. When did they shift? Premises in the year 2016 and 2022. So the repetition was pending at that point of time. Then they knew it very well. All these repetitions pertain to the same period.
Yes, sir.
Then so when the litigation have already notice has been issued, then in that case, how is it possible? Huh? No. The notice was issued on 14/9/2016. So they need it.
Thereafter, they have filed affidavit in the police.
Whether the judgment in this Khyamsam of the Bombay High Court carried to the Supreme Court?
No, not to my knowledge. So otherwise also this is settled when a particular thing is required to be done in a particular manner. It has to be required, it has to be done in that manner.
That is there. The manner is a different thing.
That is what has been done in these cases.
So after 1 year, if it is done, then it would have been proper. That can't be the law. Too much. This court, by the order dated 12/9/2023, directed Mr. S.C. Kyle, the counsel for the Income Tax Department, to produce the records pertaining to the reassessment proceedings so initiated against the petitioner. However, Mr. Kyle submits that the said records at present have not been traced, could not be traced. And department for whom he represents seeks for an accommodation so that the records can be produced on the next stage. Taking into account the above, list the matter again on 16th of November 2023 at the top of the list. But this time you get it elsewhere.
Why not, do I need to clarify the zero cost?
That I will take it on that date. Yes, any more urgent matters? Otherwise I write. Yes, Mr. Deka, what is your matter? You don't have any urgency from your face of it resembles.
Now, we have an urgency in the sense that it's a second round. What you could recall that matter pertaining to acquisition.
Which one?
But it was an acquisition under the Assam Fixation of Ceiling on Land Holding Right. Where we had the two new grounds. First of all, that the entire process was carried out universally procedure order. And secondly, the land in question was already classified as town land. Later on, there were instances when the state had released other land, holding the town land cannot be a.
Isn't that the matter where I made it the interim order until further orders?
Still made a Sarkari in the record.
Why the matter always keeps on coming to this court?
But it was fixed by your lordship.
I fixed it, yes.
Your lordship has,
Yes, Mr. Bobujari, what do you have to say?
My lord, I have received a communication, my lord, from the office of the deputy commissioner. I mean, my lord, they are paid for some further time, my lord, because
For what?
I have to produce the records pertaining to the ceiling case. Because desire to
There was no,
otherwise,
there is no draft, final notification.
final statement, there's an admission from the revenue authority and then
There's
it
no-
was never published.
That is what, I remember that.
In fact,
So, without publishing of the final statement, what right do you have over the land?
every officer has a review.
That is why I asked you to produce the records as to whether the final statement has been produced.
because one of the things, affidavit is also not submitted to the estate, my lord.
They would not.
One affidavit, my lord, filed by the revenue department, of course, my lord, but their affidavit is not specific with regard to application of the final statement. So, under their circumstances.
No, but Mr. Bobujari, without the final statement under section 7, it has no meaning.
No proceedings could I have done, yes.
And now too, you cannot, taking into account now it is townlands. Can you?
And it is there.
If it is townland, then it will come under the urban ceiling, ne?
Well, which is of course not.
Now, they say, my lord, that they are in a position of that.
In fact, we are still in occupation, no compensation has been paid, nothing on record, it is shown as Sarkar. And by, it was done in 76 or not, no settlement.
When, enough, there's too much. We have given you a lot of electricity. Enough. And this case, from the start I have become a judge, it has just comes only before this. This case came in the year 2021 first, before this court. And I heard it. Then the government was not filing an affidavit. I said, okay, interim order to continue till the year. I issued rule. Then the matter came before another court. Again, it came up before admission before this court. I said, I have issued, I remember by heart that case. So I said, I have issued rule. Then also it comes. Then I again mentioned that I have issued rule, listed for hearing. Again, the matter comes before this court as hearing. There is something, there is some matter by which it is not leaving me.
I will be effective execution of the matter.
This is,
That's allowed to see, but LNTC did acquired it on paper. Possession was still with me. They did not give compensation, neither have they allotted it, because the purpose of singing was to take it from me and then vest it upon agriculture. That also
no,
did not-
why should we go into that aspect so far? If no, is no section 7 matter ends there.
At one of the persons, one of the officers, the deputy commissioner, I think, we have a conference with the members. Also,
I asked last time to produce the records,
yes, now the difficulty.
but the records have not been produced.
The record one of, for the reason one of this, one of, so by the time one of this Kamut Metro and Kamut Rural. It is not there, one of, in Amindo, it is not there, now, so Amindo, they will now retain to Kamut Metro to search for the record, if it is there, my lord. So that is the difficulty. Because it is the whole pending case, whether it is contingent of the same. That is the difficulty, otherwise, my lord, it has been the same mistake, my lord, Mohammed Sukhana, my lord. Definitely, my lord, there is a sequence, my lord, we can get one of the records. But now since it is a defined listing, they do not have any administrative control over Kamut Metro. So therefore, they have written it to the, that Kamut Metro.
You are appearing for whom?
For the revenue department.
So revenue department is the head of the, all this revenue records.
It is one of the, right to the revenue department, they will get it to the.
Whatever may be. Then,
No, communications are there, but now this is the.
as to whether we are concerned whether the proceedings initiated under the fixation of land ceiling held was at all culminated.
In fact, one of them said that they don't have, each 120.
They don't have, they are saying it. There's no quarrel with that. That is why once the records come, we finish it up. But no further time, because they want to do something. They want to build something.
Something to deal with.
Huh?
Deal with that somehow. Put it to fruitful use.
How much? How much area?
100.
Where?
It does.
No, your government, otherwise we have sold it for 1,000 rupees per bita. You have the habit of doing that. It's a different thing.
In fact, my lord, the commissioner and secretary revenue and disaster management had said that there is no record of the concerned LA proceeding to prove that the copy of the final statement was published. Neither there was any record to suggest that the final statement was served upon the Pattadar. Entire endeavor would
Last order, when did the matter come last?
last 12/9.
This court, by an order dated 12/9/2023, had directed the respondent authorities to produce the records pertaining to the sealing proceedings initiated in respect to the lands belonging to the petitioner. However, the said records have not been produced today. Mr. B.D. Dekar, the learned counsel appearing on behalf of the petitioner, submits that for the last, how many years you have been stranded?
Since 2009, I.
Before. Since 1976, the petitioners have not been able to put to use the land, although there has been no order, there is no final settlement in terms with Section 7 of the Assam Fixation of Land Sealing Act. Assam? Land?
Of sealing on land.
Fixation of Sealing on Land Holding Act 1956. And as such expresses urgency in the matter. Taking into account the above, this court grants the respondent authorities a final chance to produce the reports by 21st of November 2023. Failing which, this court shall have no other option but to seek the personal appearance of the concerned official on such date and time as may be fixed by this court. I'm not giving it. Failing which,
there is every possibility that the records may not be found.
That is why I have said, failing which this court may fix such the personal appearance of such provisions on such date and time as may be fixed by this court. Why I have done it is this order may help you to get the records and not, then I will consider.
Otherwise, madam, where respect to the and madam, consider this, if the records are not good, on the basis of the materials and.
No, that I would not do it now. Then I will ask them to file an affidavit that the records are not available. Because then only, because if I do it, tomorrow you are going to go and file an appeal, then look here, this single judge has done all these things. And he will be again put to the streets.
Absolutely not, madam, absolutely not. I will be the last
Isn't
person
it?
to do that.
So, but therefore, it is better to have it in this manner. So the records are clear. So if I fix it and next day I'll ask, if you don't produce the record, I'll fix it and I ask him to file an affidavit. If they file an affidavit that records are produced, they won't do it. Unless that last line is not there, they would not do anything. Sitting out here for 2 years, I realized that there has to be some fear installed. Otherwise, nothing happens.
Because your lordship has already heard it.
What?
But all we are expecting that.
Not part of, you see,
Either of the.
you see, Mr. Deka, we are in live streaming. The file is still there. I remember by heart the facts is a different aspect of the matter. The file is still there, and you are saying it to make it partial.
At least add two or on the top.
For a matter to be taken up on insurance, they will fix it. At least for further consideration. No, 21st.
I'm online.
I have to make a, because if I not at least it is,
15?
I don't know.
What is that?
Getting given the compensation for allotment of land to him. It's going to be directed to contacted.
Huh?
It's going to be directed to contacted.
And you have not got the money,
No, no. Not that.
and you are for? Together. The money must be high. Huh? Both the lawyers are shaking their heads. Anyways, you are there for APDCL.
It is for it is done.
Why you are not paying the compensation to madam?
On last occasion, what is the benefit to have the instruction and then the joint verification?
Some validation.
At joint verification, some instruction given.
The land was acquired. Demand number 5. Oh, it's a long order passed. Instead is whether the petitioners herein are entitled to compensation from the respondent demand. The case of the petitioner hearing is the petitioner agreed by the non-payment of compensation by the Gosar respondent Assam in respect to the land which have been occupied by the hearing on behalf submitted. There are 2 aspects. The first aspect pertains to occupation of APCL over the land belonging to the petitioners, and the second aspect pertains to the land allotted to APCL when a subsequent factors have been issued to the petitioner. Submitted petition has the request to APCL initiated and deliberated pursuant to the material depending to the same development. Upon the opinion of the government is carried out, the report of the same being the interest. The petition of the argument carries the land to the land. This was observed in the report of the Valium shall be construed of the land to the total. Would be paid. Yes.
For the instruction of the petition,
For more time you are asking.
they have fixed the date for joint verification because of the whether they said that it is not possible now.
You are fixing a date for joint verification in the month of December. They don't have time. Then they will say that we are having the 50-year celebration, so we cannot hold it.
They said that, it must be completed on 39/23 due to bad weather. They, if they say that first verification of APGCL forest department and petition will start 39 the weather comes to normalcy. Therefore, the date is the rest.
Date for joint verification is fixed up on 10/12.
As it seems from the state.
What about October, November? Why? Huh? Pursuant to an order dated 1/8, you could have done it, then you were fixing it on 39.
This has been constantly, Kazema.
Why? Why this long time? Huh? You have no control. Yeah? Now, this code by an order dated 1/8/2023 had permitted the Karbi Anglong Autonomous Council to carry out the joint verification and submit the report before this court. And the same would be in the interest of justice for an effective adjudication of the dispute. Today, Madam, your name? So and so, appearing on behalf of the Karbi Anglong Autonomous Council, have placed an instruction dated 4/10/2023 issued by the Joint Secretary, Department of Revenue, wherein it has been mentioned that the joint verification could not be completed on 30/9/2023 due to bad weather. However, the joint verification with APGCL, Forest Department and the petitioners would start soon as the weather comes to a normalcy. Therefore, the dates are fixed. Therefore, dates have been fixed in that regard. It is also seen that on 10/12/2023 is the date fixed for joint verification of the site, and 27/12/2023 has been fixed for submission of the joint verification report. Taking into account the above, this court fixes the matter on 23rd of January 2023. 23rd will be closed. 23rd is Netaji's birthday. We'll have it on 25th of January 2023. Huh?
January 2020. January.
Oh, okay. 25th of January 2024. The authorities, the respondent authorities shall take effective steps so that on the next date, the joint verification report is placed before this court without fail. List according. Oh, sorry, Philip.
Hey, that's